So I'm gonna do the bond.
Real quick. As a matter of fact, I haven't even looked up all the information, but I'll get a chance to.
Yeah, so if we want to do it.
Good afternoon, Ms. Bridgewater. Hope you're doing well.
I am, Your Honor. How are you today?
Doing fine, thank you. Let's see, the SAP reset date.
It's May the 21st.
Okay, thank you.
Mhm.
And just before we get started, I guess, Ms. Falk, I got those consent orders that you sent for positions, I believe. One,
I have them too, so
okay, so I've signed them, 14 Francois and Mason,
Mhm.
position 24.
Thank you, Your Honor. I appreciate that.
Thank you, I appreciate it.
We have a little bit of a backup at ACDC today. There were several people there, so I know I've got a couple of people to interview, and Miss Kim has perhaps Miss Atai as well. Also, one of my clients there speaks Ethiopian, so I guess they're working on the interpreter.
Okay, thank you, Mr. Cook.
PD Cook, the person who needs an interpreter is the person who just received a consent bond signed by myself and PD Haddad on Saturday.
Oh, that's
believe that's Abdullah.
Abdullah?
Yes.
Okay, thank you. That helps a lot.
Okay, we'll get started when courtroom 2 comes on.
And Your Honor, we are going to have an add-on, Sherrod Thomas. I'm working on getting that worked up for court.
Okay, thank you. Not like we don't have enough to do already, Ms. Falk.
Miss Falk. Okay.
Attorney McKinnon, are you on with me?
Yes, Your Honor, I'm here.
Yes, good afternoon. This is the misdemeanor first appearance calendar. You have position number 21, Ms. Johnson?
Yes, Mr. Johnson, yes, sir.
Mr. Johnson, okay, I will let courtroom 2 know that you're with us when they join us, okay?
Thank you, Your Honor. I appreciate it.
Okay, and you've already had the opportunity to speak with the state and with your client?
I've spoken with my client, not the state, Your Honor.
Okay, very good. We'll be with you. Thank you.
Thank you so much.
You're welcome. And good afternoon, Ms. Chansey. Thank you for being here this afternoon with us also. Do you know which positions you're here on for today?
I don't know the position, Your Honor.
Okay.
It's position 22.
22. Okay, thank you, Mr. George. And who do we have at the Alpharetta Jail?
Yes, sir.
Yes, who do we have there?
Hello, say your name. Say your name.
¿A quién tenemos aquí? ¿Cuál es su nombre?
Ángel Danilo Juárez Gómez.
Ángel Danilo Juárez Gómez.
Okay, and thank you. And he's the one apparently who needs the interpreter. Whose client is this?
I'm sorry.
Oh, I'm trying to sound for who's going to represent Mr. Gomez this afternoon. Mr. Cook, can you tell me whose client this is? Position number 22.
My client is Juarez Gomez.
Yeah,
Is-
that's him, Miss Kim.
That's me.
Do you need to talk to him?
Yes, Your Honor.
Okay, so let's just go ahead and put you into a breakout room now so we can get that
Yeah.
done. Alpharetta Jail, who's there? We're gonna place you all into a breakout room, okay?
Thank you.
All right.
Señor,
Sí.
ya nos van a llevar a hablar con usted.
I did. Thank you, Mr. Howard. And courtroom 2, we're ready whenever you all are ready.
Good afternoon, Your Honor.
Afternoon, Deputy Norris. We about ready to get going?
Yeah, we're still trying to get things situated here, but we have a private attorney here for Mr. A.
Oh, okay, let me go ahead. Norris, just so you know, position 21, we also have a private attorney, McKinnon. So if we can maybe take, if you have him in the courtroom with you next, maybe we can take that next. Let me make a general announcement to everyone since we have so many people here today. Good afternoon, gentlemen. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video to help prevent the spread of the virus. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. If you do not have a private attorney, we will provide you with the assistance of a public defender today if you choose. We are conducting these hearings today by video. If you have an objection to your hearing being conducted by video, please let me know that when you come before me. Good afternoon, counsel. Who do we have first here?
Position 17 and 18, Mr. Hay.
Okay,
Good afternoon, Your Honor.
good afternoon.
My name is Jamie Herman. I'm here for Mr. Hague.
Thank you, Mr. Herman. Mr. Hague, you've been charged in case 24 CR 002816E with battery and in case 24 CR 002817E with simple assault, family violence, and criminal trespass. Is there a history, Mr. Howard?
No, first arrest. You need a cosign. If you give him
Okay.
some.
Yes, Ms. Falk.
Yes, Your Honor. So firstly, I just need to let the court know as to the battery case. We have sent that to the DA's office for transfer. The DA's office has accepted that case for transfer. We are waiting on the transfer order. I have reached out to Edie Hutcherson to send that back to me before the end of court today. So I am asking on that case that we do that, given that the venue is now with Superior Court, that we do not address that case since the DA's office has indicated they are taking the case and will sign the transfer order. I can send that over to Your Honor for his review, the email between myself and Edie Hutcherson where he has accepted that case. The reason why the DA's office accepted that case is because in that case, the victim, Mr. Ahmad El-Khafif, his arm was broken as a result of the incident involving the defendant. The defendant essentially attacked him. He was a valet at a hotel and the defendant attacked him. He as a result, his arm is broken there. He is currently still at the hospital. There has been a specialist brought in to review his injuries before he goes into surgery, but he is getting prepped to go into surgery. And we received that information from both the victim and the victim's friend who was with him at the hospital, who was able to provide the rest of the information to our victim advocate. And so for that reason, that is why the DA's office has accepted the case.
That will be placed on felony first appearance tomorrow.
Yes, that is what we are requesting. And we would just like to ask so that we're in compliance with the code section that Your Honor just notify the defendant that that case will be heard tomorrow on the felony first appearance calendar.
And there's not a Riverside issue?
Not if Your Honor announces to the defendant that he will be heard tomorrow at the felony first appearance calendar.
Your Honor, if I could be heard on that point, I would say that my client has been here, was arrested on Friday afternoon. This is his first time seeing a judge, so he has been in court since Friday. So I understand Deputy Chief Falk's position, and she's been very forthright in providing information to us, which is very much appreciated. But I would ask that Your Honor consider, to the extent possible, the possibility of providing a bond for him today. And I can provide that at whatever time the court is inclined to hear it as to why.
And Your Honor, I would like to just go over the remaining charges of simple assault, family violence, and criminal trespass before Your Honor hears from the defense. However, I will state that the defendant's arrest was at 3:24 p.m. on May 3rd. So this is not a Riverside issue and will not be one, again, if Your Honor simply announces on the record that he will be going to felony first appearance on that other case. As for the simple assault, family violence, and criminal trespass, that incident took place at 468 Danesfield Drive in Milton. Officers spoke with Mr. Adam Hay, who is the who is the father of the defendant, who stated that the defendant was attempting to break windows in their house and their vehicle. He also advised the defendant has been diagnosed with THC psychosis, and that is the reason for his actions. He stated the night before the incident, the defendant had attempted to make food, turned the oven up, and passed out, likely from drug use, which resulted in an oven fire. And when confronted about it, the fire the next day, the defendant, according to the victim, flipped. He then proceeded to flip over multiple planters, solar lights, which were all the property of Adam Hay, and then pushed and threw those items off of the porch and walkway. The victim, Mr. Hay, attempted to calm the defendant down. He took a wooden step ladder and threw it at Mr. Hay, missing him. And officers did observe multiple potted plants flipped and pushed over the landing, along with lights which had been thrown on the ground. The second incident, which I'd already stated the DA's office has accepted for transfer, happened at Hotel Avalon at 9000 Avalon Boulevard in Alpharetta. That occurred on May 3rd. That was the incident that resulted in his arrest. The defendant accused the valet of stealing marijuana from him and was upset. The victim in this case did not know what the defendant was talking about, tried to explain that to the defendant. The defendant then grabbed him, twisted his arm behind him back, forced him to the ground, and proceeded to beat him while he was on the ground. The victim was unable to move his right shoulder and then was transported to North Fulton Hospital, whereas you've heard from the state, he is still there 3 days later and is going to be taken into surgery for a broken arm. The recommendation as to the simple assault and criminal trespass is going to be a $1,500 surety bond. We're asking for no further violent contact with Mr. Hay. Stay away from 12468 Danesfield Drive in Milton, and Family Violence Intervention Program. We did have a chance to speak with Mr. Hay. He stated that they lived together at that incident location. He did confirm the events in the warrant. He stated that the defendant was having a mental health emergency and he never gets violent with him, but he does become destructive. He stated that they have been in contact and living together since the incident. The defendant has since apologized and committed to continue treatment, and that he is not in fear of the defendant and wants him to return back to the residence. That's all for the state.
Okay, Mr. Hay, I see you. The court, now is your opportunity to do so. You, of course, do not have to, but if you would like to address the court, I'll need for you to raise your right hand for me. Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can place your hand down. Yes, sir. What would you like to tell the court?
Your Honor, the issue that happened that day was my son was upset. We were having an argument at the house about him taking the car. All the facts are accurate. There was damage done to the plants outside, and as well as there are some small solar lights outside that got damaged. That being said, my wife and I had no idea that when we called the police, that they would be required under a Family Violence Act to bring charges against him. We were really hoping that it would just, help us resolve the issue by having police presence. We did not want to press charges, but I understand through the Family Violence Act, or I'm not sure if I'm even quoting the right act, but that we weren't given that option. And I understand the reasons behind it and why you would do that. This is not a case where we have any fear of our son whatsoever. And we're anxiously waiting for him to come home as soon as possible. And but we did not want to press charges, and we have no worry about him harming us or harming himself.
Okay. So you like him back in your household is what I hear. You telling me, and that you and your wife don't fear him.
Yes, we would like him as home, back in the house as soon as possible. And my wife and I and the other siblings do not fear him.
Okay. And has this been an ongoing issue?
No, Your Honor. This is the only time we previously, Andrew he's seeing a therapist as well as a psychiatrist to help him with the issues that he has had. And those have been successful. Andrew just recently is coming off about 10 months of being sober, and in recovery. He goes to meetings regularly. And but No, we've never, I wouldn't call this regular. We had an issue that morning and we called the police in a hope to kind of have an authority figure to calm the situation. And it resulted in us being here today.
Okay, thank you, Mr. Hay, for being here this afternoon. We appreciate
Your Honor,
it.
Thank
I
you,
do
Your
have
Honor.
a question for Mr. Hay.
Yes.
Okay.
if I may. Mr. Hay, did you indicate to police that you thought that this incident was brought on by the defendant's drug use?
So I think that there was an evening before the defendant, I think was possible. He came home and late and I was already in bed and he attempted to make a meal. Then he went to sleep on the couch and the meal in the oven. I came down when the meal in the oven, was overcooking and smelled. And so I came downstairs and turned off the oven. I thought because of the fact that he fell asleep while cooking, it was probably, either had been drinking or some kind of drug use. That's why he was sleeping on the couch. You don't usually just start cooking and fall asleep, but that's what I thought. I may have told the police that I thought that as well.
So at this point, well, at the time of the incident, it was not your belief that he had been continually sober for that 10 months.
No, it was previous. The incident before that was where he was sober.
Okay. All right.
Yeah.
Thank you.
Yep.
Okay, thank you. Yes, counsel.
Thank you, Your Honor. Mr. Haig is 18 years old. He's lived here his whole life, Your Honor. He is dealing with significant mental health and substance abuse issues that he wants to address. Interestingly, Your Honor, when I came to visit him on his own accord before I had even said anything to him about consequences of the case or what he would be required to do, he told me that he wanted to, as soon as he gets out, enter into a 90 and 90 program, attending 90 meetings in 90 days, and returning to sobriety. We've had extensive conversations about the people that he's hanging around with and his influences and how he can get on that path to sobriety. He is not a flight risk. We would ask, Your Honor, he's also not a threat to the community. He does not know the victim. This was an incident in which he thought that the victim had taken his property, not excusing the alleged behavior or minimizing it, Your Honor, but there's no ongoing relationship between him and the victim. He doesn't know the person. He has no intention or desire to contact them. He has no prior arrests, never been in trouble before. The incident at addressing the March incident, that was an incident, Your Honor, in which his parents, as people often do when they are dealing with people with mental health crisis, may call the police because they're looking for some help to calm the situation down. They were not calling the police because they were considering what he was doing to be criminal in nature or threat to them. They were trying to calm the situation down. Unfortunately, the police felt compelled to issue warrants. On that particular day, Mr. Haig did reach out to the police, imploring them to withdraw those warrants because they did not want to see, he and his wife did not want to see their son charged. He is committed to, upon his release from custody, entering into the 90-90 program, following the recommendations of his providers and getting on the path to sobriety. If you would just ask, Your Honor, that you consider a reasonable bond, we would ask for a signature bond on the misdemeanor, the simple assault and criminal trespass charges. To the extent that you can provide a bond on the battery charge, we would ask for a signature bond there. Again, he's not a flight risk. He has every intention of addressing this case and takes this matter seriously.
Okay, I'm going to let you make your argument as far as the battery tomorrow at the first appearance felony calendar, since apparently I've already signed that transfer.
Your Honor, I don't want to misrepresent. You have not signed the transfer order. We've sent it over to be signed. The DA's office accepted the case.
Okay, well, I will sign that order here very soon, and I'll let them deal with that tomorrow. As far as the simple assault and criminal trespass goes, it will be a $2,000 signature bond through pretrial level 1. He will need a cosigner for those. So it's 2,000 per charge, makes for a total of a $4,000 signature bond through pretrial level 1. No further violent contact with Mr. Haig, and no drugs, alcohol, or weapons while out on bond. Okay.
Thank you, Your Honor. To be clear, he is allowed to return to the residence. Correct?
Yes, I'm not keeping him from his family, given what his father's told me this afternoon.
Thank you, Your Honor.
Okay.
Will
All right, good
pretrial
luck.
reach out to his father regarding, I'm sure his father is, in terms of a cosigner, is his father able to be the cosigner?
Yes, his father should be able to be a cosigner.
Is pretrial able to provide a phone number or some method of contact to coordinate the co-signing?
Mr. Howard?
404-613-4845. That's the intake unit, but well, he gotta go to court tomorrow, so he might as well wait to cosign because they may have to bond him out on that felony charge.
Okay.
All right.
Also, pretrial, just so I can make sure, so the victim on the case can co-sign for the defendant's bond?
The dad, the victim?
Yes.
Oh, it's not supposed to be. I wasn't listening, so I'm still prepping.
No, I
But,
understand.
I mean,
Okay.
if the judge order it, it's whatever the judge order.
We would just ask if you, especially considering Mr. Haig's position that he did not want to see it prosecuted, if you could either order that either Mr. Haig or his wife, Lisa Haig, can be authorized to co-sign.
And that's fine with me, either the mother or the father. Is it Lisa?
Yes, Your Honor.
Okay, so we'll make sure that we have both those names down.
Thank you, Your Honor.
All right, you all have a good rest of your afternoon.
Thank you, Your Honor. May I be excused, Your Honor?
Yes, thank you.
We could go to position number 21.
Okay. And yes, good afternoon, Mr. Johnson. You have been charged in case 24 CR 002820 with speeding, improper erratic lane change, reckless driving, fleeing or attempting to elude a police officer, a seatbelt violation, hit and run, failure to obey signs or control devices, knowingly driving a motor vehicle on a suspended, canceled, or revoked registration, and laying drags. Is there a history, Mr. Howard?
Fifth arrest. Giving false name, possession of a Schedule 2 out of Gwinnett County. He got histories of drug possessions. That's all.
I have
Did you-
9 charges.
But
What?
Johnson?
Yes, Asami Johnson, number 21.
I got this is fifth arrest.
Right, so I'm just trying to make sure that I have all the charges given how they're laid out.
Oh.
Yes,
Paul,
we have
I have-
9 charges as well, Your Honor.
Okay, just wanted to make sure.
I can go through them. We can go through one by one when I break down the bond.
Okay, thank you.
So on May 3rd, 2024, the following events took place at an intersection at Roswell Road and Piedmont Road in Atlanta. And I just want to, for the record, state that the defendant was actually arrested the May 4th at 1:01 a.m. So this is not a Riverside issue. So the defendant was driving Mercedes-Benz GT, was going 70 miles per hour on a 35 mile per hour public road. The defendant failed to operate his car in a single lane, ran a red light at the intersection, got into an accident with another vehicle, and then fled the scene. And when the uniformed officer in the marked patrol car attempted to initiate a traffic stop, the defendant refused to bring his vehicle to a stop and turn the vehicle in such a way as to move in a zigzag circular course, causing it to gyrate around before accelerating at a high rate of speed, and then drove his vehicle on the wrong side of the road at approximately 120 miles per hour. Additionally, the defendant was not wearing his seatbelt while operating the vehicle, and the registration for which the vehicle was registered under had been suspended. The state is asking for an $8,000 surety bond broken down as follows. For count 1, speeding, $500. Count 2, improper and erratic lane change, $500. Count 3, reckless driving, $2,000. Count 4, fleeing and attempting to elude, $2,000. Count 5, seatbelt violation, $500. Count 6, hit and run, $1,000. Count 7, failure to obey signs and traffic control devices, $500. Count 8, knowingly driving on a suspended registration, $500. And count 9, driving in a zigzag course, $500. That would be a total of $8,000 surety bond, and we're asking the defendant absolutely not drive during that time, as well as have no alcohol, drugs, or weapons. That is based on the manner of driving in this case, which was extremely dangerous and could have resulted in injury to others, as well as the fact, and he did actually hit another vehicle, and due to the fact he has that open possession of controlled substance, giving false information to law enforcement officers from 2020, as well as a Florida a case in Florida from 2017 for grand theft third degree that was then dropped. So he also has a multi-state offender. That's all for the state.
Yes, Ms. McKinnon.
Thank you, Your Honor. As far as the Florida case, he was not convicted in that, so I would ask that would not be considered by Your Honor this afternoon. With regards to the Gwinnett County case, that was something that it's a 2020 case, Your Honor. My office is on top of that, and we'll be sending over paperwork regarding that hold. It should be in either this afternoon or first thing tomorrow morning. Respectfully, we would graciously accept the bond that was presented by the state, Your Honor, and ask that Your Honor sign up on the bond for Fulton County, please, at this time.
Is your client working, Ms. McKinnon?
Yes, he's working. He's also the breadwinner. He has a 1-year-old daughter. And we respect the position of the court for him to refrain from driving. His mother and sister are joined on the Zoom. They'll be available to provide transportation for him to get to work.
Okay, as such, that there is no objection to the state's request. I'll go through them. For the driving, a $500 good bond. Speeding, improper erratic lane change, a $500 good bond. Reckless driving, a $2,000 good bond. Attempting to elude, fleeing, $2,000 good bond. Seatbelt violation, $500 good bond. Hit and run, $1,000 good bond. Suspended or canceled registration, $500 good bond. Laying drags, $500 good bond. That makes a total of an $8,000 good bond. No driving, no drugs, alcohol, or weapons while out on bond.
Your Honor, thank you, Your Honor.
Yes.
On his booking sheet, he has a total of 10 charges.
Okay. Do you know which 2 that I missed that are on your booking sheet?
I have 8, Your Honor.
Failure to obey signs and control devices.
That's a part of the 8.
Oh, it's
It should
a
be
different one.
9 altogether.
It says
That's listed.
hit and run, duty of driver, stop at or return to scene of accident.
That's all one.
That's all together.
So that was put.
I have
number
10 as
6.
well.
They're separate on his booking sheet.
And that's why I wanted to go down. Because the driving hit and run, although it's separated from the duty of a driver to stop at or return to the scene of an accident, is actually the same
And
charge.
charge. Mhm.
Your Honor,
Right? Yes,
if I may,
Ms.
can I
Bridgewater.
just go with what I show on the calendar, and if you all will follow me, please?
okay,
On the first one, it has driving, speeding. And on that one as well, it has driving improper erratic lane change. Is that
okay,
not
so
two?
those are
That's
two.
two. Okay, and then in the very next one, it has reckless driving. And then driving, fleeing, or attempting to elude. So that's four right there.
That's, yes,
Just kept me
Then
with
we
that.
have a seatbelt violation,
that's
which is
5.
5. Driving hit and run, which is 6. Duty of driver to stop, that's 7.
No, that goes with.
Okay, that goes
hit
with
and
that one.
run.
Okay,
Yeah.
okay.
That's part of the hit and run.
Mhm.
Okay, so that's where it's misleading. Okay.
Yeah. For some reason, Ms. Bridgewater, it does that on the calendar every time we have a hit and run. It
Okay.
separates them out into 2 charges.
Okay,
All right, so do you have it all, Ms. Bridgewater?
yeah, I have it all.
Okay, do you
And-
have
and
it
I
all?
believe-
Cor-
Oh, sorry, Your Honor. I was just
No.
going to say, I believe why it's showing 10 for the jails, because I just looked at the jails as well. The foreign charge out of Gwinnett is on that list.
No, I
The
didn't
foreign
count,
hold.
I didn't count the foreign hold.
Oh, well, I'm only seeing 9 on the jail screen.
Yeah, I see 9. With
Okay.
So Judge Morrow, what was the bond for the number 7 paid to base signs or control device?
Oh, that's 500, right?
That is correct, Your Honor. State requested 500.
Okay, so we all have it all totaling up. Do we have all the charges and all totaling up to 8,000, everyone?
Yes. And
Courtroom
if I
two?
may, Your Honor, request a copy of this bond order, please. I don't know who's on the screen that can send that to my office.
Okay, I'll have to get it signed first, Ms. McKinnon, and then I'll get it
course.
back to Ms. Bridgewater. And then once Ms. Bridgewater has it, if you'll place your information in the chat, I'll have her send it to you.
Will do. Thank you, Your Honor.
Okay, are we clear?
We're
So
clear.
it all totals up to $8,000 good bond, correct, Your Honor?
Yes, that's correct, Norris.
Thank you.
Mr. Fortis, who is your client this afternoon?
Your Honor, that would be Jesse Askew.
Is that a man or a woman?
It's a male.
It's a male. Do we have Mr. Askew in courtroom 2?
we do, Your
Yes,
Honor.
yes, we do, Your Honor, but can we take
Okay.
care of one person right before Mr. Askew? I have him going after this.
Okay,
next.
all right, we'll be with you, Mr. Fortis.
Thank you, Judge.
And Your Honor, before we proceed, were there any other special conditions on Mr. Johnson?
No driving and no drugs, alcohol, or weapons.
Thank you.
And
Okay,
this concludes my business, Your Honor. May I be excused?
yes, have a good afternoon, Ms. McKenna.
Thank you. You too as well.
Thank you. Who do we have now, courtroom 2?
Position number 6, Mr. Michael Brown.
Okay. Mr. Brown, you've been charged in case 24 CR 002783G with battery, family violence, and criminal trespass and damage to property. Is there a history, Mr. Howard?
It's the 9th arrest on probation, terrorist threats, reckless conduct, pointing pistol at another. 2019 violation of family violence order conviction, disorderly conduct NOLO. 2019 other terrorist threats. That's it.
Falk?
Yes, Your Honor. The defendant in this case was on May 4th, 2024 at 6968 Canewood Drive in Atlanta. The defendant arrived home after being in Ohio for several weeks. According to the family, the defendant threw all of his belongings into a neighbor's yard and began destroying a Bible on the front lawn of his mother's house, Miss Teresa Fulton. The defendant then came inside the house, grabbed a broom from Miss Fulton, and struck her in the face and pushed her to the ground. The officers did observe that Miss Fulton's eye was swollen. They also spoke to Diamante Miller, who is the younger brother of the defendant, who was witness to the incident and stated that the defendant struck Miss Fulton in the face and struck holes into the walls of the home. We were not able to make contact with Miss Fulton, but would like to still sound for her. I will say that the defendant has 2 cycles out of Illinois, a 2021 domestic violence that was dismissed and a 2021 obstruction of justice that looks like it has been filed with no disposition. We also have an aggravated assault, family violence, battery, and terroristic threats and acts, which is on the dead docket. It was a 2015 offense here in Fulton County, a 2020 conviction for terroristic threats and acts and criminal trespass, a 2019 conviction for violation of a temporary protective order and disorderly conduct, and then a 2022 probation violation. That's in addition to the case that he's currently on first offender, which is that 2020 aggravated assault, terroristic threats and acts, and reckless conduct, as well as simple battery, family violence. He was sentenced in 2020 and still remains on first offender probation on that case. For those reasons, especially for the number of cases that involve violence or threats of violence, we are asking for a $5,000 surety bond. That's going to be $4,000 on the family violence battery, $1,000 on the criminal trespass. No further contact with Teresa Fulton, that is Foltin. Stay away from 6968 Canewood Drive in Atlanta. We are requesting family violence intervention program as well as no firearms. That's all for the state. And we would like to again sound for Miss Teresa Fulton.
If Ms. Fulton is on the line and wishes to address the court, now is your opportunity to do so. This is your case, Mr. Cook?
Yes, Your Honor.
Mr. Brown has his hand up. I don't know if you need to talk with him before you make your presentation.
We've talked. I would ask him not to say anything at this point, and I will make our case.
Okay, go ahead. And Mr. Brown, place your hand down. I see you there. So you have a right to remain silent. Anything you say can be used against you. Mr. Cook is going to speak on your behalf. Go ahead, Mr. Cook.
Yeah, my client denies the allegations as stated in the warrant. He's 30 years old. He is gainfully employed as a forklift driver in the area, has lived in the Atlanta area his whole life. Would have no problem with any stay away or no further contact. We would be asking for a signature bond at whatever level the court deems appropriate.
Okay, for the battery, family violence, a $2,000 good bond. The criminal trespass, a $1,000 good bond, makes for a total of a $3,000 good bond. No further contact with Ms. Fulton. Stay away from the Canewood Drive address. No drugs, alcohol, or weapons while out on bond. Okay, Mr. Brown, you'll have your opportunity to make your case at a later time. This is just a bond hearing this afternoon. Anything further on this, Mr. Cook?
Nothing further, Your Honor.
Okay. You want to handle that in the courtroom for me, Deputy Norris?
Give me life. You think I did some shit with my fucking mom? Y'all look at me.
Next, we can go to position.
Hey, bro.
Next, we could go to position number 2 and 3.
I was hoping to go to, is that,
This is Askew.
oh yeah,
That is
Askew?
yeah,
Okay.
that is
thank
Mr.
you.
Fortis's case.
Thank you. Good afternoon, Mr. Askew. You've been charged in case 24 CR 0027778H with battery, family violence, criminal trespass, and damage to property and unlawful conduct during a 911 call, and also in case 24 CR 0027779H with battery, family violence, and willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
16, 2 FTAs from 2020, one from 2018 simple battery conviction, 2017 ag battery first offender, 2017 simple assault NOLO.
Ms. Falk?
Yes, Your Honor. There are two separate incidents that occurred in this case. The first is going to be an incident on December 10th of 2023 at 789 Hammond Drive, apartment 1802 in Sandy Springs.
I'm sorry.
Officer met.
Which case number are you referring to? I apologize.
Oh, my apologies. The case number that I'm referring to is the first case on the calendar, position 2. Which is ends 2778H.
Okay, go ahead, Ms. Falk.
All right, so the officers met with Lucille Tully, who stated she and the defendant had dated for approximately 1 year. And when she allowed the defendant to live with her during that time, she stated the defendant returned to pick up some belongings and an argument ensued, and the defendant broke a glass container belonging to Tully. The defendant also attacked Ms. Tully, leaving her bleeding with a busted lip and scratches to her neck. The defendant then repeatedly called 911, harassing the 911 operators and stating he did not care that he was abusing the line. The second incident happened on February 7th of 2024 at the same address, 789 Hammond Drive. In that incident, the defendant entered the apartment of Ms. Tully and started throwing her things around. Defendant struck her in the face several times, and officers noted cuts and bruises to her face. We did have a chance to speak to Ms. Tully, and she stated that she and the defendant are in a relationship. They currently do not live together and they share no children. She denies the events in both incidents and stated that they were both intoxicated. And she has also stated that they have not had any altercations since, and that they have been in contact since this incident, and she wishes to continue to be in contact. Despite that, the state is still asking for a no further contact in this case due to the fact that there were 2 incidents within a 3-month period of time. Due to the circumstances of this case and the time of the arrest, the state is agreeing to a $5,000 signature bond through pretrial services. On both, we are requesting level 3, as well as stay away from 789 Hammond Drive, apartment 1802 in Sandy Springs. No further contact with Lucille Tully, no firearms, and no alcohol, drugs, or weapons. That's all for the state. And that is a $5,000 signature bond through pretrial services level 3 on each. So a total of a $10,000 signature bond through pretrial services level 3. We're also asking for family violence intervention program as part of that. That's all for the state. We would like to sound for Miss Lucille Tully or Miss Lucille Tooley.
I see you on the line, Ms. Tooley. If you would like to address the court, now is your opportunity to do so. You, of course, do not have to, but if you would like to address the court, you'll have to unmute yourself, activate your camera, and I'll have to swear you in. All right.
Hi.
Yes, ma'am. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay. What would you like to tell the court?
So we can't have any contact because we are in a relationship still.
That is what the state is asking for. First of all, can you pronounce your last name for me?
Tooley.
Tooley. Yes, Miss Tooley. What would you like to tell the court regarding you having contact with Mr. Askew?
So we are still in a relationship and we do live together. So I would like to have contact with him. We are going to do counseling and everything like that. So
okay,
yeah.
so you've had to call the police at least on 2 occasions to manage Mr. Askew. Have you had any problems since December 10th or February 7th of this year?
No.
Okay. And are you living together at the present time?
Yeah.
Are you afraid of him?
No.
Okay. Thank you for being here, ma'am. Mr.
Your Honor,
Portis?
I do have one quick question for Ms. Tooley.
Yes, go ahead.
Ms. Tooley, do you recall telling our victim advocate, either Ms. Cheney or Ms. Maldonado, that you two do not currently live together?
No, we do.
Okay. All right. Thank you.
Yes, Mr. Portis.
Thank you, Judge. Mr. Askew, he's 30 years of age. He's been in the car business for the last 5 years where he sells cars for a living. These two instances are isolated instances. I had spoken with Ms. Tooley prior to this court date, and she had indicated you want to have contact, and I would ask the court to grant contact between the two. I think it was isolated because they had been drinking and the emotions got the better of them on 2 occasions. So since then, my understanding is that they're no longer, drinking, and they're keeping the straight and narrow on that. And so the relationship tends to be on the right track. What I would ask the court to do, rather than $5,000 on each case for 10,000 signature bond, I would ask the court for $2,000 good bond on both cases. And, just so the court can have, some, I guess, it has some pause maybe on the reality of what happened. I would ask the court to go ahead and instruct him to get enrolled in the FFIP. I don't think that's an unreasonable ask from the state, but I would ask for $2,000 on each case for a $4,000 good bond total.
Okay, I don't usually have it going that way, Mr. Fortis, but as long as he enrolls in is willing to enroll in the Family Violence Intervention Program, Ms. Falk, do you want to chime in on any of this?
State doesn't object to the surety bond or the Family Violence Intervention Program, Your Honor, but the state does still object to the contact, given there were 2 separate incidents within 3 months that required the police to intervene, as well as the defendant's prior history that does involve violence.
And let me say this, and what Ms. Falk's job is, but the reality of it is Ms. Tooley's on the phone. I mean, she's a grown adult and she wants contact, and I don't think that she needs the state to intervene on her behalf. And I think that if she were afraid of Mr. Askew, that she would advise the court of such, and then maybe a no contact provision would be justified, but I don't see it here. She took the time to get on the call. She was sworn in and she testified. And I think that they should have contact because that's what she wants.
And with all due respect to Mr. Fortis, she did involve the state in her personal affairs because she called the police on 2 separate occasions.
Sure.
Okay, so anything further? If not.
No, Judge, the reason I'm asking for the $2,000 on each case for a surety bond, because he's going to enroll. I'm hoping that you'll require that he roll in the FFIP. And so that's why I think that is reasonable.
Okay. So for the battery, it'll be $1,000 good bond, criminal trespass, a $500 good bond, unlawful conduct during a 911 call, $500 good bond, makes for a total of a $2,000 good bond, enrollment in the Family Violence Intervention Program, no drugs, alcohol, weapons while out on bond, and no further violent contact with Ms. Tooley. Case number 3, the battery, $1,000 good bond, the obstruction, $1,000 good bond, makes for a total of a $2,000 good bond. Also the enrollment in the Family Violence Intervention Program, no further violent contact with Ms. Tooley, and no drugs, alcohol, weapons while out on bond. All right. Good luck to you, Mr. Askew. Mr. Fortis, your client has his hand up. I don't know if he has a question for you, courtroom 2.
Best interest at this time.
Okay, so Mr. Askew, Mr. Fortis says that he'll get in touch with you. Okay, so you can expect his call. You can ask him your question then. All right.
That be excused?
Yes. Have a good rest of your afternoon, Mr. Fortis.
You too.
Thank you. I have been requested, courtroom 2, to go to the Gomez case.
I think he needs to be interviewed with the
we interviewed him before you got on, since we had some time today. But I do know that they need a breakout room for some reason, so is it convenient to go ahead and do that now?
I mean, yeah, because he's not in courtroom too. He's at Alpharetta, so.
Right, yeah, so we see him here, so that's why we were able to go ahead and have him interviewed earlier today. So if it's all right with courtroom 2, we'll go ahead and go to the breakout room with the Alpharetta jail.
Okay.
All right.
Not a problem.
Okay, thank you, I appreciate it. So who do we all need besides, I know Miss Kim, Miss Chansey, the Alpharetta jail, Mr. Graham, is this your case?
Yes, Your Honor.
Okay, anybody else besides myself that needs to be in the breakout room? So if we can go ahead and do that, please.
Two good ones. All right.
Miss Kim,
Yes,
can you call back? You still have one female left.
sure. I'll call right back. Thank you.
Alrighty.
Okay, let's see, where would you all like to go now?
What was the bond for the?
Oh, it is a $3,000 good bond for position 22.
We could go to position number 4, Mr. Matthew Banks.
Okay, Mr. Banks, you've been charged in case 24 CR 002780J with simple battery family violence and simple battery against a person who is pregnant at the time of the offense. Is there a history, Mr. Howard?
Fifth arrest. Got an open sale of marijuana out of Cobb County. On probation, possession of marijuana out of Cobb. 2017 probation, 2016 simple battery conviction. That's it.
Falk.
Yes, Your Honor. This is a cross warrant case with Inawan Wilson, which is position 43 on the calendar. I was wondering if ACDC could bring her forward to address both cases at the same time.
I'm sorry, which one, Deputy Chief Folk?
Inawan Wilson?
She's actually on the phone now with Miss Kim.
Okay, well, we can just go ahead with this one, Your Honor. Mr. Matthew Banks on May 3rd, 2024 at 1995 Rambling Lane Southwest.
Miss Falk, I'm sorry.
Yes, Your Honor.
If she's on the phone with Miss Kim, Mr. Cook, are you representing Mr. Banks?
I am normally on these cross defendants, they're considered conflicts, so
Right,
they're
that's what I
private
was-
attorney.
Right, that's what I'm sorry, Miss Falk, I didn't mean to
No,
interrupt.
no. I didn't realize that they were on this case as well.
Okay, so do we have I guess we don't have a conflict attorney available.
No, Judge, we weren't able to get anyone today.
Okay, so, well, I guess we can let Miss Kim know that there will be an issue, so I'll address the co-defendant when I get to her and give her her options. Okay, so let's just go forward with Mr. Banks. Thank you.
So, Your Honor, we have 3 conflicts. So
I'm
does
saying-
that all of them?
Right there. And Your Honor, just so Your Honor knows, Myosha Rainey and Javon Tyson, those 2 are cross warrants as well. And I'm not sure who the third one would be, other than maybe Maria Odom. Her victim is on the felony calendar today.
The third one is James Rachel's.
James, pardon?
Yeah,
James
it's James. It's good afternoon. It's position 32. We represent the alleged victim on a felony.
Okay, good afternoon, Mr. Dodders. Good to see you.
Good to see you, sir.
Okay, so we'll take them when we get to them.
Okay. Yes, Your Honor. On this case, on May 3rd, 2024 at 1995 Rambling Lane Southwest in Atlanta, Defendant Banks and Defendant Wilson were arguing, and Defendant Banks tried to take Defendant Wilson's PS5 from her and began punching her. Defendant Wilson then bit Defendant Banks, leaving a bite mark and laceration on his arm. Defendant Wilson is 5 months pregnant, and the couple have been living together for 9 months. The state's recommendation is to both was a $3,000 signature bond through pretrial services, 1-day anger awareness, no further contact with one another. And we are asking that Defendant Banks stay away from the location, as well as no alcohol, drugs, or weapons. So that was the state's recommendation as to both.
Okay, so $3,000 signature bond through pretrial. No further contact.
1-day anger awareness, stay away from the incident location for Matthew Banks, and then no alcohol, drugs, or weapons for both. So that was the state's recommendation as to both on this particular case.
Any objection to any of that, Mr. Cook?
Your Honor, my client has made plans to stay away, so he can do that. We would object to the anger awareness course.
Okay, will he need a one-time escort?
Yes,
Okay.
And
So
Your Honor,
if-
sorry, Your Honor, I didn't mean to interrupt. The division of that bond would be 1,500 per count.
Okay, that's what I thought. So 1,500 for each count makes a total of a $3,000 signature bond through pretrial level 1 day anger awareness, no further contact with the alleged victim, stay away from the Grambling Lane address. He can go back to that address on one occasion with law enforcement to retrieve any belongings, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Banks.
thank you.
Next, we could go to position number 7.
And Your Honor, before we go to number 7, Ms. Folk,
Yes.
Farrah Wright, she's not on the calendar. I just want to know what happened with her.
Right. I did reach out to the litigation manager who prepared the calendar and asked that she be added on to the add-on, as well as Sherrod Thomas.
Okay,
But I
thank
have
you.
not received confirmation for either yet.
Well, I have Sherrod Thomas as an add-on. I just need her.
Okay,
All right, thank
so
you.
I will reach back out and re-request.
Thank you.
And this is Mr. Browning.
Yes, Your Honor.
Okay, yes, good afternoon, Mr. Browning. You've been charged in case 24 CR 002790J with simple battery family violence. Is there a history, Mr. Howard?
11 total. 2024 battery DV obstruction. That's open. 24 CR 001833J. Got an open terroristic threats, felony obstruction, disorderly conduct. 23 CP 219852. 2020 FTA, 2019 probation. 06 armed robbery conviction. That's it.
Falk?
Yes, Your Honor. This is Jonathan Browning, correct?
Yes.
Okay. This incident happened April 20th of 2024. Officers were called out to 272 Glen Street Southwest. Lakita Goolsby stated she was kicked in the mouth and the chest by the defendant as she was trying to gather her items after being kicked out of the defendant's apartment at that location. The defendant had, according to Ms. Goolsby, her cell phone, birth certificate, social security card, driver's license, and crutches. I will state that we did have an opportunity to speak with Ms. Goolsby. She and the defendant are no longer in a relationship. They no longer live together and they don't share any children. Ms. Goolsby did confirm the events in the warrant. She also said this is not the first time this happened. The defendant and Ms. Goolsby have an open case with this court, 24 CR 001833J. In that case, Judge Law on April 12th, 2024, 8 days before this incident, gave a $2,500 surety bond, as well as a no further contact with Lakita Goolsby and stay away from 272 Glen Street if the victim, Ms. Goolsby, is residing there. She stated that she has since left the residence and moved out of state, and they have had phone contact since this incident. She does want to continue contact. However, as I have already stated to Your Honor, there was already a bond with a no further contact provision that this defendant has already violated with the court. The defendant also has a open felony case under 23 CP 219852, where he was given a $7,000 surety bond for obstruction, terroristic threats and acts, and disorderly conduct. That was against a different victim. For those reasons, the state is asking for a $2,000 cash bond, both for the fact that the defendant has violated the already stated conditions of bond 8 days after those conditions were set. And in addition, also injured and, well, not injured, but also attacked the victim yet a second time. We're asking for no further contact with Ms. Lakita Goolsby, no alcohol, drugs, or weapons, and no firearms, as well as family violence intervention program. That's all for the state. We would like to sound from Ms. Lakita Goolsby at this time.
Ms. Goolsby is on the line and wishes to address the court. Now is your opportunity to do so.
And Your Honor, I would also like to state that the defendant was arrested on this case yesterday at 2:25 p.m.
Thank you. Mr. Cook?
Yes, Your Honor, we would object to the cash bond. We would be seeking a surety bond at whatever level the court deems appropriate. We would also object to the FVIP. She lives out of state now, I believe, in Mississippi, so he should be able to go back to the residence with no problem, and he has no objection to no further contact.
Okay, be a $5,000 good bond, no further contact with Ms. Goolsby, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Browning.
Next, we could go to position number 8, Mr. Brandon Burke.
Yes, good afternoon, Mr. Burke. You've been charged in case 24CR002784Y with simple battery family violence. Is there a history?
No.
Ms. Falk?
Yes, Your Honor. This incident happened May 4th, 2024 at 2110 Godby Road in Atlanta. Miss Ceresia Clems stated she was in a verbal altercation with the defendant, who's the father of her child. She stated he pulled her hair and continued to do so after she told him to stop. And the defendant did admit to doing the act, and he stated he was trying to get her attention. This is the defendant's first arrest, and we did reach the mother of Miss Clems, who stated she would try to get in contact with Miss Clems. I would like to sound for her at the conclusion of my recitation of facts. The state is agreeable to a $1,000 signature bond through the jail, no further violent contact with Miss or no further contact with Miss Ceresia Clems, and no alcohol, drugs, or weapons. The defendant was arrested on this case on May 4th at 2 a.m.
Cook?
You know, we have no objection to the SOB to the jail and no further contact. We would ask for a provision that would allow a third-party transfer of the children they have together. I think they move back and forth anyway, from what I understand, but we would like to be able to affect that without violating the no contact provision.
Okay, Ms. Clems is on the line and wishes to address the court, please. This is now your opportunity to do so. All right, $1,000 signature bond through the jail, no further contact with Ms. Clems. Stay away from the Godby Road address, third-party transfer of any minor children for visitation, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Burke.
Next, we go to position number 10, Mr. John Davis.
Good afternoon, Mr. Davis. You've been charged in case 24CR002809G with criminal trespass. Is there a history, Mr. Howard?
No.
35. Last arrest was May 1st. Possession of a Schedule 2. Possession of drug-related objects, 24PR003044. That's a pretrial bond. On probation for trespass, possession of drug-related objects, 23CR008155D. 2024 trespass obstruction conviction. He already got 2 trespass convictions from this year. He got an extensive trespass history. 2022 FTA, 2020 fade to appear.
Thank you, Ms. Falk.
Yes, Your Honor. This happened May 5th before at the Atlanta Marriott Marquis Hotel. Officers were dispatched there at 265 Peachtree Center Avenue in Atlanta. They met with security, who explained that the defendant had been detained. The defendant had returned to the location after being criminally trespassed from it on a previous case, and the defendant was placed under arrest. We are asking for, and let me just make sure I heard this correctly. Pretrial services, he already has a pretrial bond outstanding.
Yes.
So the state would ask for a $250 surety bond, stay away from the Atlanta Marriott Marquis Hotel located at 265 Peachtree Center Avenue in Atlanta, no alcohol, drugs, or weapons. That's all for the state.
Cook.
Your Honor, my client is 34 years old, lives from shelter to shelter. He's not employed. He has no income. And for that reason, we would be asking, we have no problem with the stay away or the no alcohol, drugs, weapons. But for that reason, we would be asking for a signature only bond at the level the court deems appropriate.
How many pending criminal trespass cases does he have open in Fulton State Court?
Let me see. Pretrial, could you give me the date of birth? Would you mind?
I have to pull the history because it's not on my notes.
Don't
Now,
worry about it.
he got mostly trespass convictions already. He don't really have open like that.
So he doesn't have anything. Well, what's the pretrial?
That's felony.
That's
That's
felony.
possession of a controlled substance.
So he doesn't have any other cases open in state court.
I'm looking right now,
Not
Your
that
Honor.
I
No,
saw.
does not.
He's just on probation for trespass in state court.
That's correct. He had 2 cases, well, 3 cases, one in January, one in February, one at the end of February.
Mr. Cook, I want a social worker to visit him to assist with housing if he needs.
Yes, I can.
Okay, all right, so it's gonna be $1,000 signature bond through pretrial level 1 per the judge. Stay away from the Marriott Marquis, social worker visit to assist with housing, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Davis.
You too, sir. God bless.
You also.
Next, we can go to position number 13, Mr. Yates Edmonds.
Mr. Edmonds, you've been charged in case 24 CR 002812F with simple battery. Is there a history, Mr. Howard?
7 total. 2023, possession of a firearm during a commission, possession of a Schedule 5 and a seatbelt. It's 23 CP 219055. I didn't see any violent convictions.
Falk.
Yes, Your Honor. The incident that happened was on May 5th of 2024 at 855 Trestle Tree Court, Southeast in Atlanta, Georgia. Officers responded to a fight and call progress. They spoke to Miss Natalie Neal, who stated she was sleeping when her boyfriend, the defendant, woke her up asking for a hug. She stated she was just waking up and did not want to give him a hug, at which point he sat on her and began choking her. She did describe, when we spoke with her, the pressure as an 8, that she had difficulty breathing, but she did not feel like she was going to pass out. She then began screaming for her son to call the police, which he did. Her son, juvenile AN, stated to police he heard his mom yelling for him to call the police. And when he came into the room, he saw the defendant choking the victim in this case. As I stated, we did have an opportunity to speak with the victim in this case, and she did state that they do not live together. They do not share any children, and that location is her address. She stated that the 3 children walked in and witnessed the defendant choking her, and that before the officers arrived, he threatened to come back after he was released from jail and choke her again. She also stated that he has been sending her threatening messages since his mother has been sending threatening messages since he has been arrested. This is not the first time this incident has happened. She stated back in September, he did this again in front of her children to the point where she blacked out, and she did not call the police excuse me, she did call the police, but the defendant left the scene before the police arrived. She stated she wants no contact with the defendant, wants him to stay away from her residence, and she does plan on filing a TPO. I would like to sound for the victim at this time, Miss Natalie Neal, and the state would ask for a $7,500 surety bond. No further contact with Natalie Neal. Stay away from 855 Trestle Tree Court in Atlanta. Family violence intervention program, no alcohol, drugs, or weapons, and no firearms. We would state that the defendant does have it looks like an open possession of a Schedule 5, possession of a firearm during commission of a felony case under 23 CP 219055, which does give the state concern, being that there was a firearm involved in that case. That is all for the state. We would like to sound for Miss Natalie Neal.
Still, I see to address the court. You don't have to, but if you would like to address the court, now is your opportunity to do so. If you would like to do so, you'll have to unmute yourself, activate your camera, and I'll have to swear you in. It doesn't appear that she wishes to address the court. Ms. Atai?
Yes, Your Honor, my client is 25 years old. He has lived in Georgia all his life. He's a high school graduate and also attended Atlanta Metro, where he studied business management. Your Honor, he has no conviction. So, I mean, he has no criminal history, no violent history. I think a $7,500 good bond is extreme. He's charged here just with the simple battery. I would ask for a signature bond through the jail. He is recommending for a signature bond through the jail, and I would object to an FVIP. He does deny the allegations as they're stated in the warrant, and he has no violent history. At the most, a one-day anger awareness, if that's necessary. No further contact and stay away is fine with him. He has another place to live, and they don't need to see each other. Nothing further.
$5,000 signature bond through pretrial level 1, one-day anger awareness, no further contact with Ms. Neal, stay away from the Trestle Tree Court address, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Edmonds.
Go ahead and have a seat in the back. Next, we will go to position number 16, Mr. Joshua Gore.
Yeah, Mr. Gore, you have been charged in case 24 CR 002818Y with battery and theft by taking. Is there a history, Mr. Howard?
No.
Ms. Falk?
Yes, Your Honor. I didn't hear the first and last name. It broke up.
Joshua Gore.
Okay, Joshua Gore. Yes, Your Honor. This incident happened October 29th of 2023. Law enforcement arrived at 7357 Malhana Lane in South Fulton in reference to a domestic dispute call. Upon arrival, they made contact with Genesis Flowers, who stated she had gotten into an altercation with the defendant, her ex-boyfriend, about their relationship coming to an end. The victim wanted the defendant to delete personal videos of her from his phone, which he refused to do. When she was attempting to get out of the vehicle, the defendant grabbed her by the sweatshirt, pulling her back into the vehicle, causing her to bust her lip. The defendant then grabbed her cell phone, tossed it into the bushes. She then went to retrieve her cell phone and attempted to enter the residence, but the defendant followed her. He then snatched Ms. Clower's cell phone from her, got into his vehicle, and fled the scene. The incident was captured on surveillance footage from a neighbor's Ring doorbell camera, which confirmed Ms. Clower's how she related the events to the officers. The state is asking for a $3,000 surety bond, no further contact from Miss Genesis Flowers. Stay away from 7357 Malhana Lane, South Fulton. We are asking for anger management classes, as well as no alcohol, drugs, and weapons. The split of that bond would be $2,000 on the battery, $1,000 on the theft by taking. At this time, we would like to sound for Miss Genesis Flowers, and the state has nothing further.
Claus, see you there on the line. If you wish to address the court, now is your opportunity to do so. You certainly do not have to address the court, but if you wish to, you will have to unmute yourself, activate your camera, and I'll have to swear you in. Yes, ma'am. Can you raise your right hand for me? The other hand? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down, Ms. Flowers. What would you like to tell the court?
So with the contact, it won't be no contact, so we can't talk to each other or nothing no more.
You would be, if I ordered no further contact, you would be able to have no contact whatsoever. No phone contact, no personal contact, no email contact, no social media contact, no contact whatsoever.
Okay, well, I still want the contact.
Okay, let's see, are you afraid of him?
No, sir.
And have you been in contact with him since October 29th of last year?
Yes, sir.
And have you all had any problems since that time?
No, sir.
Do you all live together?
No, sir.
Okay, anything else you'd like to tell the court, Ms. Flowers?
That's it.
Your Honor, I do have a question for Ms. Clowers.
Okay.
Ms. Clowers, do you recall how the defendant came to be arrested on Friday at 10 o'clock at night on May 3rd?
You want me to tell you what happened?
Was it because you called the police?
Yes, ma'am.
And was it because of a physical altercation the two of you were in that resulted in you calling the police, which resulted in him being arrested?
Yes, ma'am.
So when you just told Judge Morrow that there hadn't been any incidents since this past incident.
Yeah, until now, to that Friday, everything was good until that Friday.
Right, but do you recall Judge Morrow asked you about the incident, the original incident for which he was arrested, and you said there hadn't been any problems since then?
Yeah, to that incident on Friday.
Okay. All right. That's all for the state, Your Honor. I just wanted to point out that there has been an incident for which Ms. Clowers failed to disclose to the court that recently happened as of Friday night.
When was he also arrested? I take it he wasn't arrested for that.
He was not, but he was arrested
But
on
he-
the outstanding charges, and it was enough that Ms. Clowers decided to call the police because she was concerned for her safety, which is different than what she was saying just now.
No, I understand. I just wanted to make sure that there was nothing else pending that I would have to deal with this afternoon.
Not
and-
anything the state is aware of, Your Honor.
Okay, thank you. Ms. Atai?
Yes, Your Honor, my client is only 18 years old. He is a high school graduate. He's lived in Georgia all his life. He is gainfully employed at Amazon. He does deny the allegations as stated in the warrant. This happened again, allegedly happened October of last year. Staying away from the incident location, that's the complaining witness's home, but I would ask for no violent contact. It's important because they work together. He's working at Amazon, and I believe that it's not avoidable for them to, I mean, he would have to lose his job if he were to have no contact with her. So I would ask for no violent contact. This is his very first arrest. He has absolutely no criminal history, and I would also ask for a signature bond through the jail as he is recommended, and nothing further, Your Honor.
Okay. For the battery, it's going to be a $2,000 signature bond through pretrial level 1. For the theft, $1,000 signature bond through pretrial level 1. Makes for a total of a $3,000 signature bond through pretrial level 1. 1-day anger awareness. I'm going to take you, Mr. Ty. I don't want him losing his job, so I'm going to allow them to have contact while, but I'm not going to allow him to go back over to the Malhana Lane address. I'm going to keep him from her residential address, but I don't want to affect his ability to earn a living. So if he comes into contact with Ms. Clowers, it'll be no further violent contact. No drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
All right. Good luck to you all.
Thank you.
Thank you.
Next, we can go to position number 23, Mr. Jason Lance.
Good afternoon, Mr. Lance. You've been charged in case 24 CR 002792F with simple battery family violence. Is there a history, Mr. Howard? You're on mute if you're talking, Mr. Howard.
Hold on, I didn't have Lance on here. Let me see. Yeah, I didn't have Lance in my folder. They didn't do
Okay.
him.
Mr. Graham, do you have a history?
Yes, Your Honor. I'm showing 2 arrest cycles. The previous arrest was in a conviction in 2019 for DUI. This incident took place on May 3rd, 2024. Law enforcement responded to a dispute at 638 Creekside Way in Roswell. Upon arrival, Melinda Moore advised that her husband, Jason Lance, unwantedly licked her face while she was on the phone with 911. Mr. Lance admitted to licking her face to aggravate her. Your Honor, I will point out that Mr. Lance was arrested on Friday at 11:14 p.m., so we're not running into the Riverside issue. Our office has been in touch with Ms. Moore. She says that the two are married. They do live together at the incident location. They share no children. She confirmed the events in a warrant. She stated that they were having an argument and he kept licking her face. She stated that this has never happened before. She only called the police because she wanted him to leave the residence. She's not in fear of him. She wants to continue contact, and that it's okay for him to return to the residence and that she'd be unable to attend Zoom. Your Honor, based on the limited history and the remarks from the victim, the state is requesting a signature bond through the jail. We are going to ask for a one-day anger awareness, no further violent contact with Melinda Moore, no alcohol, drugs, or weapons. And if we may sound from Melinda Moore, just in accordance with Marcy's law.
If Ms. Moore is on the line and wishes to address the court, now is your opportunity to do so. Okay, Ms. Kim, if it's okay with you, it'll be a $2,000 signature bond through the jail, no further violent contact with Linda Moore, and no drugs, alcohol, or weapons while out on bond. Does that suit you?
Yes, Your Honor.
All right. Good luck to you, Mr. Lance.
Next, we can go to position number 30, Mr. Martavius Pope.
Your Honor, before you go with that one, will you tell me the bond amount on 23 again? Or the one you just did?
$2,000 signature bond through the jail.
Thank you.
You're welcome. Mr. Pope, good afternoon. You've been charged in case 23 CR 002803A with simple battery family violence and theft by taking. Is there a history, Mr. Howard?
Yeah, 17/2023 obstruction, sale of marijuana. That's open. 23 CP 215-808. Probation from 2023, 2021, 2020, 2015 failure to appear. 2014 burglary, possession of tools, conviction. And I think he got a current probation hold according to that booking sheet. That's it.
Mr. Graham?
Thank you, Your Honor. This incident took place on August 10th, 2023. Law enforcement responded to a dispute call at 490 Glen Street Southwest, apartment 204 in Atlanta. Kelsey Jackson advised that the father of her child, Martavius Pope, became upset after looking through her phone. He slapped her across the face, left the location with her phone, and would not return it. Our office has not been in touch with Ms. Jackson, Your Honor. Based on the history, the 2020 act stalking, battery family violence, and the probation violations, Your Honor, the state is requesting a $2,500 surety bond. So it's $1,500 on the simple battery family violence and a $1,000 on the theft. A one-day anger awareness course, no further contact with Kelsey Jackson, stay away from 490 Glen Street Southwest, no alcohol, drugs, or weapons while out on bond. And if we may sound for Ms. Kelsey Jackson, Your Honor, in accordance with Marcy's law.
If Kelsey Jackson's on the line and wishes to address the court, now is your opportunity to do so. Doesn't appear so. Mr. Doders?
Thank you, Your Honor. Mr. Pope is 33 years old. He is a lifetime resident of the city of Atlanta. I have good contact information, as well as a good address separate from the incident location. He also has family support, including his mom. Mr. Pope is the father of 3 children. One child does live with him while he financially supports the other 2. He is a graduate from Washington High School, and he currently works as a barber at Up 11 off of Ralph David Abernathy. Your Honor, he is clear about the VOP hold, and we would ask that if that be put on the next available SAP calendar. He is clear that that's going to continue holding him, but we would ask for signature bond on these charges from back in August of last year. When I spoke to Mr. Pope, the child that lives with him is the child that he shares with the alleged victim. He also informed me that he is the only provider for that 11-month-old child. While he's currently in custody, his mom is watching him. The alleged victim, Miss Jackson, is unable to care for the child. She was incarcerated and has been incarcerated since October of last year. So Mr. Pope is the sole provider for that child. Mr. Pope does not want any further contact with Miss Jackson at this time, but if she is able to be released and wants to be a part of her child's life, we would ask for a third-party transfer of the children. But to allow Mr. Pope to continue working once he settles this probation issue, we would ask for a signature bond.
Okay. Ms. Bridgewater.
Yes, sir.
Given that he has a violation of probation that's going to have to be heard, do you think we can get that put on the calendar for the 14th? That's a calendar that I'm on for the SAP calendar.
If you would like.
Instead of waiting until May 21st?
Yes.
Okay, so that's what I'm going to do, Mr. Dodos. I'm going to go ahead and see if I can consolidate these cases on the SAP calendar on the 14th, which is a calendar that I will be presiding over. So I'll take a look at this again then, but as for today, for the simple battery, it'll be $1,000 good bond. For the theft by taking, a $500 good bond, makes for a total of a $1,500 good bond. No further contact with Ms. Jackson, stay away from the Glen Street address, and no drugs, alcohol, weapons while out on bond. Once I hear from probation, I'll take a look at all this again at the SAP calendar and if necessary, consider a modification, okay?
Thank you, Judge. I'll let our SAP attorneys know.
All right, thank you. Good luck to you, Mr. Pope.
Your Honor, what is the recent date of the SAP calendar?
It's on the 14th of May.
For this calendar?
For this gentleman it is, but for everybody else it's the 21st.
Okay.
Okay, and Ms. Bridgewater, would you also let probation know that I would like to hear him at that time for that probation calendar? We'll have someone contact probation.
Yes.
Okay, thank you. I just want to make sure to consolidate everything.
Okay, no problem.
I appreciate it. Thank you.
Uh-huh.
Who do we have next?
This is position 31, Mr. Porter.
Good afternoon, Mr. Potter. You've been charged in case 24 CR 002807E with criminal trespass and willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
2024 trespass. He got 4 trespasses from 2017, 1 from 18. He's residentially challenged. That's it.
Okay. Mr. Graham?
Thank you, Your Honor. This incident took place May 5th, 2024. Law enforcement responded to a trespass call at the Circle K located 111 Boulevard Northeast in Atlanta. Quinton Potter had been previously trespassed from the location. On this date, he entered the store, refused to leave. Once law enforcement arrived, he refused to follow officer commands. to get on the ground. He was taken down, continued resisting arrest, causing the officer to tussle with him on the ground, kicking the officer's taser. At that point, he was able to get up and he began to run from the officer. The officer chased him both in the car and on foot and was eventually able to detain Mr. Potter some distance away. Here on the state is requesting signature bond through the jail and stay away from Circle K on Boulevard Northeast, no alcohol, drugs, or weapons.
Any objection to any of that, Mr. Dotis? You on mute.
No objection, Your Honor. I did speak with Mr. Potter and he knows to contact our office so that we can set him up with some resources to help him get back on his feet.
Okay, very good. It'll be a $500 signature bond through the jail on each count, which makes for a total of $1,000 signature bond through the jail. Stay away from the Circle K on Boulevard and no drugs, alcohol, or weapons while out on bond. All right, don't go back to that Circle K, Mr. Potter. Good luck to you, sir. Okay.
What number was that?
9.
9.
Let's see, this is Ms. Caldwell.
Yes, sir.
Yes, good afternoon, Ms. Caldwell. You've been charged in case 24 CR 00278 with battery, family violence, and willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
4th. 2012 DUI conviction. 06 shoplifting NOLO.
Okay, Ms. Falk.
Yes, Your Honor. On May 3rd, 2024 at 505 Northridge Parkway in Sandy Springs, officers spoke with Shelby Hemingway, who stated that around 9:50 p.m. after a community event at the clubhouse where the defendant drank a little too much, they returned home. The defendant slapped her on the back of the head and shoved her into a corner and into a doorway. Officers did observe black and blue bruising marks on Miss Hemingway's right arm, and the skin was broken but not bleeding. Miss Hemingway also had a red mark on her shoulder and the damage to the door frame where the wood was broken. We did speak with Miss Hemingway. She stated that she and the defendant are in a relationship and they do live together at the incident location. She confirmed the events in the warrants, but stated this has not happened previously. We will say that I'm showing a 2007 aggravated assault affray, which was no prost, and a 2013 conviction for DUI. We are asking for a signature bond through pretrial services, family violence intervention program, ADET, since there is a 2013 conviction for a DUI and the allegations in this case is that alcohol was involved. No further contact with, no further violent contact with Shelby Hemingway, no alcohol, drugs, or weapons, and no firearms. The state at this time would like to sound from Ms. Shelby Hemingway.
Yes, I'm here.
Okay, let's see. Can you raise your right hand for me?
Yes.
Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can place your hand down. What would you like to tell the court?
This has never happened. This is not her usual self. We own a successful business together. That was left out, and we do live together. This again, never physical. I am okay with the no violent contact, but still would like contact with her. Yes, but this is not like her.
So this has never happened before?
No, never. And never.
And you wish for her to reside in the household?
Absolutely. I definitely need her home. Yes.
Okay. Thank you for being here this afternoon, Ms. Hemingway.
Thank you.
Mr. Cook, is this your case?
Yes, Your Honor. Your Honor, we would be given the comments of the of the alleged victim, we would be asking for a signature bond through pretrial services, or the jail, actually. No further violent contact, we would object to the FVIP and ADET.
Okay, for the battery, it's a $2,000 signature bond through pretrial level 1. The obstruction, $1,000 signature bond through pretrial level 1, makes for a total of a $3,000 signature bond through pretrial level 1. 1-day anger awareness, no further violent contact with Ms. Hemingway, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Caldwell.
May I ask a question, Your Honor?
Yes, ma'am.
She is allowed to come home today, correct?
As soon as she's processed out of the jail, I did not restrict her from coming to the household or having any contact with you. Okay?
Okay, thank you so much, Your Honor.
You're welcome.
Next is position number 32, Mr. James Rachel.
And Your Honor, Mr. Rachels is going to need a conflict attorney, so I'm not sure how we're handling that today.
Okay, thank you. Let's see, Mr. Rachels, you have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings today. Unfortunately, we do not have a conflict attorney available to represent you. I can do one of two things. If you would like to proceed today, you can proceed pro se, meaning without the advice of counsel. If you would like to wait until tomorrow, until we can have a conflict attorney available for you, you also have that option. What would you like to do today?
I would like to represent myself.
Okay, Mr. Rachels, you've been charged in case 24 CR 002805D with battery. Is there a history, Mr. Howard?
14. Got an open case, financial transaction card fraud, obstruction, possession of tools. That's out of Franklin County. 2016 simple battery conviction, 2016 stalking. That's it.
Mr. Graham?
Thank you, Your Honor. This incident took place on April 26, 2024, and it happened at the Jamaican Bar and Grill. It's located at 4847 Old National Highway in College Park.
I'm sorry, Mr. Graham, I have it happened in 23. Is that wrong? I have April 26, 2023.
I'm sorry, Your Honor. Just 1 second. I'll take a look. Yes, Your Honor, that is correct. It was just a typo.
Okay, I just wanted to make sure.
Yes, thank you. Thank you.
Go ahead.
So April 26, 2023, at the Jamaican Bar and Grill, while at the location, Dominique Davis was confronted by his former girlfriend, Rachel Rachels, about slashing her tires. Miss Rachels brought her brothers with her, one of which is James Rachels. They physically assaulted Mr. Davis, resulting in a busted lip, swollen eye, and a laceration to the top of his head. Our office has been in touch with Mr. Davis. He stated that Mr. Rachels is his ex-girlfriend's brother, whom he has never had a problem with until that day, that they've known each other for about 15 years, and they were close and had always gotten along. He was having issues with his girlfriend at the time, who was the sister of Mr. Rachels. She accused him of slashing her tires, confirmed the events in the report, and added that he should have gotten medical attention because he's got some numbing on the left leg for days after the injury. Stated that there have been no further incidents and that he would like no contact and anger awareness. Your Honor, the state is recommending a $2,000 surety bond, 1-day anger awareness, no further contact with Dominique Davis. And we're also going to ask for a stay away from that American Bar and Grill restaurant, no alcohol, drugs, or weapons while out on bonds. And if we may sound for Dominique Davis at this time, Your Honor.
Mr. Davis is on the line and wishes to address the court. Now is your opportunity to do so. Okay, it's going to be a $3,000 signature bond through pretrial level 1, one-day anger awareness, no further contact with Mr. Davis, stay away from the Jamaican Bar and Grill, and no drugs, alcohol, or weapons while out on bond. So I'm going to give you a signature bond, Mr. Rachels, but you have to make sure to show up for your next court date, okay?
Yes, sir.
All right, good luck to you, sir.
Thank you.
You're welcome.
Please go to next.
Yeah, I'm having difficulty hearing, so who do we have next?
34, Mr. Victor Rose.
Good afternoon, Mr. Rhodes. You've been charged in case 24 CR 002806C with one misdemeanor offense and the offense of criminal trespass and damage to property. Is there a history? Mr. Howard?
Yeah, I'm good on that. 16 total, 2021 obstruction felony. Possession displays use of ID of another without consent. That's 4 counts. 3 counts of financial transaction card theft. Has a probation hold as well. And violent history, that's all.
Ms. Graham?
Excuse me, thank you, Your Honor. This incident took place on May 4th, 2024. Law enforcement was advised of a burglary call at 372 Griffin Street Northwest in Atlanta. The responding officer read remarks from dispatch that stated a man wearing all white was dragging a silver suitcase and that he had broken into the residence, pointed a firearm at the owner. The officer did see Victor Rhodes walking down the street, matching that description. He was detained. I was speaking with the caller. The first name I'll spell Taorid, last name Adefosobi, Adefesobi. Advised that Mr. Rhodes came to his property. He saw him through the Ring doorbell, told him to leave the property, to which Mr. Rhodes responded that he had made a reservation at the Airbnb. He then went to the corner of the porch and urinated. After being told to leave again, Mr. Rhodes responded by saying, "If I were to shoot you right now, I'd be wrong, and I should smoke you right now." No firearms were located on his person, Your Honor, or in the suitcase. Mr. Rhodes damaged the lock to the gate of the residence in order to gain access to the porch. We've been unable to contact the homeowner, Your Honor, based on the open probation hold. The state is requesting a $1,500 surety bond. That's $500 on the criminal trespass and $1,000 on the second charge. No further contact with the homeowner. Stay away from 372 Griffin Street Northwest. No alcohol, drugs, or weapons.
Sedaris?
Yes, Your Honor. Mr. Rhodes is 35 years old and a lifelong resident of the city of Atlanta. I have a good stable address for him, as well as 2 separate numbers to stay in contact with him. As noted, he does have a VOP hold for case number 19CR009190E that will continue to hold him. Your Honor, I would just ask for a signature bond or a reasonable bond. He's fine. He has no reason to go back to this address, so we're fine with no further contact and a stay away from the incident location. We would ask that both of this case as well as his probation hold be addressed at the next available SAP. And I would like to note that Mr. Rhodes did speak with officers. He did advise that he knocked on a door, but he stated he did not break the lock or enter the residence.
Okay, it'll be a $500 good bond on each charge, makes for a total of $1,000 good bond. No further contact with the alleged victim. Stay away from the Griffin Street address. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Rhodes. Who do we have next?
Position 19.
Okay. Good afternoon, Ms. Henderson. You have been charged in case 24 CR 002815J with driving while your license was suspended or revoked, giving false information to law enforcement, no insurance, expired or no license plate or decal, and child or youth restraint not properly used. Is there a history?
2023 simple battery against police, felony obstruction, on probation out of Cobb, ID, theft fraud. 2020 suspended license NOLO and wanted out of Cobb County.
Ms. Falk?
Yes, Your Honor, this incident happened on May 4th, 2024 at Camp Creek Parkway and North Commerce Drive in East Point. Law enforcement observed the defendant driving a 2017 Honda Accord at the intersection and initiated a traffic stop for a separate traffic offense. During the traffic stop, it was determined that the defendant was uninsured. The registration was expired as of July 6th of 2022, and there was a 1-year-old in the front passenger seat not secured by a seatbelt. The defendant who was driving falsely provided the name of Jenna Martin, born February 25th, 2002, several times to the officer before finally admitting that her real name was Dewana Henderson, born July 5th of 1983. It was then determined that the defendant's driver's license has been suspended and surrendered as of December 27th of 2022 for failure to appear. The state would be requesting in this case a $2,500 surety bond. That's going to be $500 on each count with the condition of no driving. The reason we are asking for that, Your Honor, is due to the number of arrests and convictions for driving without a valid license, as well as giving false names. She has a giving false name from 2001, 2002, 2003, 2004, several other giving convictions for giving false name, driving while license suspended in 2009, driving while license suspended arrest in 2019, 2020, and an obstruction simple battery against a police officer in 2023. She did plead in 2020 to NOLO on that driving while license suspended. So that is the basis for our request. We are also asking that she not drive any motor vehicle until she has a valid license and valid insurance, and no alcohol, drugs, or weapons. That's all for the state.
I'm not sure whose case this is, Ms. Ty.
Yes, no. Yes, Your Honor, my client is 40 years old. She is the mother of one minor child, and she recently took in another minor child, her cousin, who was recently placed into her custody. She has lived in Georgia all her life. I understand that there's some driving history, Your Honor, but she is just charged with traffic offenses here, giving false information. She does deny the allegations as they're stated in the warrant. I would ask, because she is taking care of 2 minor children, one is an infant, Your Honor, and then the 11-year-old who is in her custody, she needs to be able to take care of specifically that child. So that the child doesn't go into the care of the state. I would ask for a signature bond through pretrial services. I have no objection to no driving without a valid license. Nothing further.
Your Honor, I would like to add that the defendant does have a hold out of Cobb County, and the bond was currently set at $7,780. So the state's departure downward to $2,500 is a significant downward departure from what the bond was originally set at in magistrate court.
Oh, that's right, Your Honor. She does also have the Cobb County hold, and she has been here since May 4th. So she's gonna sit here, who knows how much longer waiting for Cobb County.
Okay, for each charge, it'll be a $500 signature bond through pretrial level 1, makes for a total of a $2,500 signature bond through pretrial level 1. No driving without a valid license, and no drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Henderson.
And Your Honor, could we add no driving without license or insurance?
Okay, and if you have a car, make sure that the car that you're driving has insurance on it. Ms. Henderson. So you don't drive a car without a license and don't drive a car without insurance, all right?
Yes, sir.
All right, good luck to you, ma'am.
Thanks.
25.
Next, we will go to position number 35, Mr. Brandon Smith.
Okay. Good afternoon, Mr. Smith. You've been charged in case 24 CR 002793B with loitering and prowling. Is there a history, Mr. Howard?
No.
Okay. And this is your case, Ms. Bakaki?
Yes, Your Honor, this is my case. This incident occurred at 422 Bryan Street, Atlanta. The defendant is accused of walking around the residence of Mr. Greg Thomas Van Ladenham and attempting to gain entry into the residence by twisting the front door knob. The defendant's attempt to enter the residence was caught on video surveillance. The state is recommending a $1,000 surety bond through PTS. Stay away from the incident location, no further contact with the victim, Mr. Van Laningham, and then no drugs, weapons, or alcohol while out on bond. At this time, I will sound for the victim, Mr. Van Laningham.
Did you mean a signature bond through trial services?
Yes, that was a signature bond through pretrial services.
Okay. And Mr. Van Lant, what's the last name?
Van Laningham, VANLANINGHAM.
Okay, if Mr. Van Laningham is on the line and wishes to address the court, now is your opportunity. Okay, Mr. Dotis, any objection to any of that?
Your Honor, this is his Mr. Smith's first cycle, so I would just ask it to be a signature bond through the jail. Mr. Smith has no reason to go back to that address. He doesn't know that address or the person who owns it. Mr. Smith went out for Cinco de Mayo and went home and thought he was at the right Airbnb. He was not at the right Airbnb, and he tried to enter what was not his Airbnb. It was an honest mistake. We just asked for a signature bond through the jail.
Okay, it'll be $1,000 signature bond through the jail. No further contact with the alleged victim. Stay away from the 422 Bryan Street address, and no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Smith.
No, you have a seat.
Okay, if someone's speaking, I'm not sure if you're talking AC/DC, we're having a difficult time hearing you.
25,
Say it again.
position 25.
25, okay, thank you. Is it Miss Mamouni?
Mooney.
Okay, yes, good afternoon, Ms. Mamouni. You've been charged in case 24 CR 002797 with battery family violence. Is there a history, Mr. Howard?
No. First.
Mr. Graham?
Thank you, Your Honor. This incident took place on May 4, 2024. Law enforcement responded to a domestic dispute at 10645 Stonefield Landing in Johns Creek. Latifah Mamouni told the 911 dispatcher that her boyfriend, Ray Johnston, had choked her, would not allow her to get out of the vehicle while attempting to prevent her from calling 911 while they were driving. The responding officer was not able to locate the vehicle, but did arrive at the residence shortly before the two arrived. Ms. Mamouni advised that the two were in a physical altercation the night before, and Mr. Johnston would not allow her to leave after he chased her around the house, grabbed her by the hair, and choked her. She had a video of the incident, but deleted it at the request of Mr. Johnston in exchange for $4,000. When speaking with Mr. Johnston, he advised that they did get into an argument the night before. He did not touch her, but she did throw a vase at him, striking him in the neck, causing visible scratches. He offered to pay her to delete the video as a means to de-escalate the situation so they could go to sleep. The following morning while they were in the car, Mr. Johnson made an audio recording and it can be heard saying to Ms. Mamouni, "You hit me." The two traded insults. Then Ms. Mamouni called the police, sobbing hysterically, saying that he would not let her out of the vehicle, was attempting to stop her from calling. The officer also heard Mr. Johnson say that he would take her home or to the police station. It was evident through the recording that she retained her phone through the incident. She had no injuries that were consistent with the narrative. Mr. Johnston did have scratches on his neck from being hit with that glass vase. We were unable to get into contact with Mr. Johnson, Your Honor. The state is requesting a signature bond through pretrial services at FVIP. We're going to ask for no further contact with Ray Johnston and a stay away from the 10645 Stonefield Landing address. No alcohol, drugs, or weapons, and no firearms. And if we may sound from Ray Johnston, Your Honor, in accordance with Marcy's law.
Mr. Johnson is on the line and wishes to address the court. Now is your opportunity to do so. Ms. Kim?
Yes, Your Honor, my client is 25 years old. She is a rising senior at Georgia State University. She is getting a degree for business management, Your Honor. Right now, since she is a full-time student, she does not have any income, so she's qualified for public defender services. Your Honor, we have no objection to signature on bond through pretrial. We have no objection to stay away from incident location and no contact with him. My client does not want to have any contact with him either. And Your Honor, the warrant clearly says that it was my client who called for a report 911, and she was the one who reported that she was choked by her boyfriend. That's all, Your Honor. Thanks.
And it'll be a $2,000 signature bond through pretrial level 1-day anger awareness, no further contact with Mr. Johnson, stay away from the Stonefield address, and no drugs, alcohol, or weapons while out on bond. Good luck to you, ma'am.
We can go to position number 37, Mr. Anthony Simmons. Come sit.
This is who?
Timmons, position 37. Good afternoon, Mr. Timmons. You've been charged in case 24 CR 002796F with simple battery. Is there a history?
This 9th. Got an open trespass out of the cab. Open case in state court, pedestrian not on the sidewalk, obstruction. It's 24 CR 001226F. 2024 obstruction. 2022 probation, 2022 simple assault conviction, 21 battery conviction. It's another open pretrial case, so it's another surrender. I don't know the amount, I didn't look it up. Just FYI.
Yes, Ms. McConkey.
Thank you, Your Honor. This incident occurred April 15th, 2024 at 135 Edgewood Avenue, Southeast Atlanta. That is the University Lofts. The victim is a GSU student named Bastina Bana. She reported that an unknown Black male with pink hair and pink clothing ran towards her and her friends and pushed her. The officer reviewed camera footage of the incident and after working with the Grady Public Safety, was able to identify the defendant. I would like to note that according to Grady Public Safety, the defendant was involved in 2 other incidents at Grady as well. The state is recommending a $1,500 surety bond, stay away from the incident location, no further contact with the victim, no drugs, weapons, or alcohol while out on bond.
Mr. Douglas.
Thank you, Your Honor. Mr. Timmons is 21 years old and a lifelong resident of the city of Atlanta. Your Honor, as we heard from his history, he is struggling with being residentially challenged, and I'm happy to try to provide him with resources, as well as having a social worker reach out to him. Mr. Timmons has no reason to return to those lofts and is clear on that. He also, the alleged victim is a stranger to him, so he has no problem with no further contact. But at this time, Mr. Timmons cannot afford any monetary amount of money for a bond, so we would just request a signature bond.
Okay, it's going to be a $1,000 good bond, no further contact with Ms. Basta, stay away from 135 Edgewood Avenue, no drugs, alcohol, weapons while out on bond, and the social worker visit. I would also like, Ms. Bridgewater, if you
Yes.
will have placed on that May 21st SAP calendar, this other charge as well, so maybe we can take care of them all at the same time. If he does not get out of custody, we can handle both these cases, hopefully on May 21st, okay?
What is that other case number?
It is case number,
I got it. 24 CR
Mm-hmm.
001
Uh-huh.
226F, as in Frank.
Got it.
okay, so Mr. Dodos, if you will have the social worker report to the PDs and for SAP again for me and advise me at that time, okay?
Yes, Your Honor.
All right, good luck to you, Mr. Timmons.
Position 26.
And this is Ms. Morrow. Good afternoon. I'm Judge Eric Morrow. This is you've been charged in case 24 CR 002799J with battery and simple assault. Is there a history, Mr. Howard?
Third adult arrest. 2019 FTA, 2019 shoplifting, 09 burglary. That's all.
Mr. Graham?
Thank you, Your Honor. This incident took place May 4th, 2024. Law enforcement responded to a domestic dispute at 993 Johnson Ferry Road in Sandy Springs. The responding officer was advised by dispatch that Sierra Morrow was chasing Timothy Richardson with a hammer. Upon arrival, Mr. Richardson advised that a verbal argument escalated when Ms. Morrow started chasing him with the hammer. She dropped the hammer, picked up a rock, and hit him with it multiple times. It ended up causing a cut to his left index finger. We've been unable to get in touch with Mr. Richardson, Your Honor, based on the history and nature of this incident. State is requesting a $3,000 surety bond. It's $2,000 on the battery and $1,000 on the simple assault. We're asking for 1-day anger awareness and ADET. No further contact with Timothy Richardson. Stay away from 993 Johnson Ferry Road. No alcohol, drugs, or weapons. No firearms. And if we may, sound from Timothy Richardson at this time, Your Honor.
If Mr. Richardson is on the line and wishes to address the court, now is your opportunity to do so. Doesn't appear so. Who's representing Ms. Morrow? Yes, Mr. Ty.
Thank you, Your Honor. My client is 31 years old. She is the mother of 3 minor children. One is a 5-year-old with special needs. He's nonverbal and needs 24-hour care. Your Honor, my client has lived in Georgia all her life. She's a high school graduate and is currently studying to be a phlebotomist. Your Honor, I was able to speak with the complaining witness, and he did state that he doesn't want contact with her and doesn't want her, well, he doesn't want contact with her. They do live together, but he does not want her to return to the home, which my client is fine with. She can stay away from there, but she cannot stay away from the incident location. This incident location is Scottish Rite. It's where she works, and the complaining witness told me that he does not work there. So I would ask for her to be able to return to the incident location. It's her work. And on that note, Your Honor, she does deny the allegations as stated in the warrant. The complaining witness showed up at her job. So that just, I mean, that tells you something right there. So again, I'm fine with the stay away, no further contact, stay away from his address, not the incident location. She does need a one-time law enforcement escort, and I didn't hear any violent history, Your Honor. I think a $3,000 surety bond is excessive. Any history was at least 6 years or 5 years. So I would ask for a signature bond through the jail so that she can get back to caring for her children, studying and working. I, of course, object to the ADET, nothing further.
Okay, for the battery, it would be a $2,000 signature bond through pretrial level 1. For the assault, $1,000 signature bond through pretrial level 1. Makes for a total of a $3,000 signature bond through pretrial level 1. 1-day anger awareness, no further contact with Timothy Richardson. stay away from Mr. Richardson's home address. She can go back to that address on one occasion with law enforcement to retrieve any belongings that she might have there. No drugs, alcohol, weapons while out on bond. Good luck to you, Miss Morrow.
Miss Morrow said that that's her address, the 3070 Waldrop is her address, not his.
Okay, well, if he is there, then she necessarily cannot be there. So if he's residing there, then if he moves out, then you can go back. But if he's still residing there, then you necessarily cannot be at that address.
Okay,
All right, good luck to you, ma'am.
thank you. We can go to position number 38, Mr. Javon Tyson.
Good afternoon, Ms. Tyson. You've been charged in case 24 CR 002787D with battery. Is there a history, Mr. Howard?
Fourth arrest. Got a drug history, no violent history. So.
Okay. Ms. Falk?
Your Honor, just to remind the court, this is the case that had Miss Myosha Rainey, who's position 33 as well. And they are cross defendants.
And Your Honor, the PD's office represents Miss Rainey.
Okay. Let's see. Thank you for letting me know. Ms. Tyson, you have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. Unfortunately, we do not have anyone to represent you from the conflict attorney's office this afternoon. As such, if you would like to proceed pro se without the advice of counsel today, you can do that. If you would like to wait until we can get you counsel, we will take up your case tomorrow. What would you like to do?
I am here to represent myself.
Okay, Mr. Tyson, thank you. You've been charged in case 24 CR 002787D with battery. Is there a history, Mr. Howard?
It's for Rainey or Tyson.
38. Javon Tyson.
Tyson was the fourth arrest. No drugs, no violence. Drug history, no violent history.
Okay, thank you. Yes, Ms. Falk.
And Your Honor, if the court could also just hear the history on Miss Rainey, the recommendation is going to be the same for both.
Okay, is this Miss Rainey at ACDC? Yes? Okay, Ms. Rainey, you've been charged in case 24 CR 002788D with simple battery. Is there a history, Mr. Howard?
Second.
Okay.
2023 terroristic threats, disorderly conduct. That's 23 CP 221407. That's a pretrial bond, so that's a surrender. That's it.
Falk?
Yes, Your Honor. This incident happened May 1st, 2024 at 1031 Calhoun Avenue in East Point. Officers spoke with defendant Rainey, who stated defendant Tyson became upset because her mother wanted him to leave. She stated defendant Tyson began yelling and screaming. Defendant Rainey stated she pushed him up against the water heater when he pushed past her. And then defendant Rainey said defendant Tyson hit her, causing a scratch to her chest and began to choke her. Defendant Rainey admitted to pouring cooking oil on defendant Tyson. Defendant Tyson stated he was trying to get his things and leave when defendant Rainey blocked him from leaving and began hitting him. Defendant Tyson stated that he pushed defendant Rainey, and then defendant Rainey poured grease on him and hit him with her pan. The recommendation for both is the same, which is a $2,000 signature bond through pretrial services, 1 day anger awareness, no further contact with one another, no alcohol, drugs, or weapons, no firearms, and ask for defendant Tyson to stay away from 1031 Calhoun Avenue in East Point, as that appears to be the residence of, at the very least, Miss Rainey's mother. I may be incorrect, but that's what it appears to be based on the fact pattern. That's all for the state.
Mr. Dodes?
Yes, Your Honor, just briefly for Miss Rainey, we're fine with the state's recommendation for the signature bond. We would object to the anger management portion, but I did speak with Miss Rainey. The incident location address is Miss Rainey's mother's house. where Miss Rainey is currently living and she wants to return there. If she couldn't, she would have had to, she asked me about options for battered women's shelters. I do want to point out that this incident occurred after Miss Rainey told Mr. Tyson that she wanted no more contact with Mr. Tyson and wanted him to leave her mother's house, which angered Mr. Tyson. So I do want to be very clear with Mr. Tyson here. If Your Honor could reiterate that he's not to have any contact with Miss Rainey or return to that incident location or wherever Miss Rainey is. They don't share any children together. Or they don't have any reason to be in each other's business. I do want to also add that I don't see anything in the warrant stating that Miss Rainey poured grease on Mr. Tyson. I do see where it says Miss Rainey also stated Mr. Rainey, which I think that was a typo for Mr. Tyson, poured grease on her. So I don't think there's anything stating that Miss Rainey poured any grease. Again, Your Honor, this was just a situation that escalated after Miss Rainey asked for someone that she was uncomfortable being around to leave her family home. So I don't think anger management, any amount of class is appropriate. I think it's more appropriate that they just, that Mr. Tyson knows to stay away from her, her mother, and her mother's home.
Okay, Mr. Tyson, do you have any belongings at that Calhoun Avenue address?
No, sir, I do not.
Okay, so for you, Mr. Tyson, it's gonna be a $2,000 signature bond through pretrial level 1 day anger awareness, no further contact with Miss Rainey, stay away from the Calhoun Avenue address, and no drugs, alcohol, or weapons while out on bond. I'm gonna give you a signature bond, Mr. Tyson, but you're gonna have to make sure you show up for your next hearing date, okay?
Yes, sir.
All right. Good luck to you, sir. Miss Rainey, for you, it's also gonna be a $2,000 signature bond through pretrial level 1 per the judge. No further contact with Mr. Tyson. 1 day anger awareness, and no drugs, alcohol, or weapons while out on bond.
Okay,
All right. Good luck to you, Miss Rainey.
thank you. Judge, we have position 27.
Okay. Yes, pronounce your last name for me, ma'am. Yes, good afternoon. You've been charged in case 24 CR 002800H with battery. Is there a history, Mr. Howard? Oh, I'm sorry. Is this Maria Odom?
Yes.
Okay, you've been charged in case 24 CR 002789F for simple battery. Mr. Howard?
Third arrest, 2022 battery. 2022 battery first offender. 2017 possession of marijuana PTI. Fourth arrest. That's all.
Okay. Who's presenting for the state?
I'm sorry, Your Honor, what position are we in?
This is position 28, Miss Odom.
It looks like Miss Ausman, Najee Ausman, NJIE, Mr. Graham.
No. This is position 28, Miss Odom.
Oh, this is Miss Odom's case.
Yes, I believe they got the numbers mixed up on me. If I
It looks like it. Hold on just a second, because this may have been mine. I thought this was the other case. It is. Maria Odom is mine, Your Honor. This incident happened May 1st, 2024 at 2242 Dorsey Avenue in East Point. The defendant bit Dewan Hill on the back of the neck and placed him in a chokehold during an argument. The two of them actually lived together at that address. Defendant Hill threw her cell phone, breaking it, and caused superficial injuries to Miss Odom's arms by fighting her. He currently has a $2,000 surety bond with a no further contact with Miss Odom. Miss Odom is currently under a first offender sentence. We are asking, based on the fact that Mr. Hill appears to have been the primary aggressor and is charged with felonies in the same case, this is a cross warrant case, even though the the felony is not with us. We are agreeable to a $3,500 signature bond through pretrial services, family violence intervention program. No further contact with Dewan Hill, that is Dijuan. Stay away from 2242 Dorsey Avenue in East Point. No alcohol, drugs, or weapons, and no firearms. That is because the no further contact with Maria Odom did not specify a stay away from that Dorsey Avenue address. And so we are asking her to stay away because he was not ordered to stay away, but was ordered to have no further contact with her. That's all for the state. And if Mr. Mr. Hill is here, we would like to sound for him. Mr. Dewan Hill. All right, nothing.
Ms. Atai?
Yes, Your Honor.
Okay.
Your Honor, my client is 27 years old. She is currently pregnant with her first child. I didn't see a lot of criminal history, Your Honor, but I did see that this is a Riverside issue. She was arrested May 1st. That's the date and exact time of the citation, and now she's having her first appearance today. So I would ask for a signature bond through the jail with no further conditions. If Your Honor is not, if you don't agree to no conditions, I would ask for, of course, no further contact with the complaining witness is fine. As you heard, he was charged with, had felony charges from this same same incident. I would object to the stay away from the incident location. It's her home, Your Honor. She states that the complaining witness was the first aggressor. She called the police. So I would ask for, no further contact, to stay away. I object to the FVIP, and I would ask for a signature through the jail, nothing further.
And Your Honor, the state's response is that although Ms. Odom may be entitled to a signature bond, she's not entitled to an unfettered signature bond with no conditions. That is not what the statute states. Additionally, if Ms. Atai wants to set her client up into a situation where the minute she goes back onto the Dorsey Avenue property, she'll be arrested for having contact with Mr. Hill, which is the no further contact that he has with her and that we're asking that she have with him. I don't understand why that situation would be set up, but that would essentially set her up in a position where she goes back to that residence, she would be having contact with a person where there's a no further contact. So that's why the state was asking for the stay away.
Well, I would ask if, I'm then at least a one-time law enforcement escort. I don't know if he is still in jail or if he is at the location, but I would like to at least have her have the chance to go back to her home.
He is no longer in custody, Your Honor. So we agree to the one-time law enforcement escort.
Okay, so it'll be a $2,000 signature bond through pretrial level 1. No further contact with Dewan Hill. She can go back to the Dorsey Avenue address with law enforcement. If Mr. Hill is staying there, then she necessarily can't stay there and will have to gather her belongings and find somewhere else to stay. If Mr. Hill no longer resides there, then she of course can reside there. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Odom.
We could go to position number 2 on the add-on calendar. Ms. Farrell Wright.
Good afternoon, Ms. Wright. You have been charged in case 24 CR 002841Y with false report of a crime. Is there a history, Mr. Howard?
Control what the heart does.
15 total. 2020 probation.
What do you mean?
2020.
I'm sorry. Someone's gonna have to mute for me. I don't sure that might be you, Ms. Kim.
I apologize.
Okay.
2020 probation, 2020 suspended license given false name conviction, 2018 probation, 2016 suspended license.
Yes, Ms. Makaki?
Thank you, Your Honor. The defendant is accused of falsely reporting that her ex-girlfriend pushed her, slapped her head, and then proceeded to swing a knife in her face. The defendant testified on December 1st, 2022 that she was lying and that her girlfriend never swung a knife in her face. The incident where she made the false report was March 9th, 2022, but the officer did not discover that the report was false until the defendant testified at court in December of 2022. The state is recommending a signature bond through pretrial services and no drugs, weapons, or alcohol while out on bond.
Kim?
Yes, Your Honor.
Okay.
Yes, my client, Miss Wright, is 41 years old, Your Honor, and she resides alone with her dog. And she is currently looking for a job. She has an interview tomorrow at 1 p.m. She has associate degree. She has been living in here in Georgia for more than 12 years. And I believe that they are still in a relationship continuously. We would like to request for signature on bond through jail. It has been very long, and that's what we are asking for. Thanks.
Okay. It'll be $1,000 signature bond through the jail, no drugs, alcohol, weapons while out on bond.
Thank you.
Good luck to you, Ms. Wright.
Good.
You're
We can go to
welcome.
position number, we have seen that one. Position number 12, Miss Marshani Duncan.
Yes, good afternoon, Ms. Duncan. You've been charged in case 24 CR 002811B with battery, family violence, and giving false information to law enforcement. Is there a history, Mr. Howard?
Duncan, third arrest, 2023, criminal damage to property, second degree, theft by taking. That's open. 23 CP 216952. On probation for possession of a Schedule 1 out of Greene County. It has a Greene County hold. I gotta run down the hallway real quick. I'll be back.
Okay, Ms. Falk.
Your Honor, and I'm also showing an arrest out of Massachusetts, for assault and battery on a family member or a household member in 2017. I'm sorry, ACDC just appeared to have gone out for a moment. This incident happened in 2024, May 5th at 1270 West Peachtree Street in Atlanta. Upon arrival, officers spoke with the defendant, who stated that they had gotten into a verbal altercation with their boyfriend, Mr. Josiah McCord, about him walking in front of her. The two of them previously lived together. She stated she thought it was rude. She grabbed his arm, cutting his skin when he pulled away from her. The officers then made contact with the victim, Mr. McCord, who had visible fresh scratches on his left arm. The victim stated that the marks on his body were very old and that he was responsible for them despite the defendant's admission. Based on the defendant's admission and the freshness of the marks, the defendant was placed under arrest. When asked for her name and date of birth while in custody, the defendant provided the false name of Mirage Duncan with a date of birth of 11/3/2001. The state is recommending a $2,500 surety bond, $2,000 surety bond on the battery, as well as a $500 surety bond on the giving false name. We would also ask for no further contact with Josiah McCord, stay away from 1270 West Peachtree Street in Atlanta. Family Violence Intervention Program, no alcohol, drugs, or weapons, and no firearms. At this time, we would like to sound for Josiah McCord, who appears to be on the Zoom.
I see you there, Mr. McCord. If you would like to address the court, I'll need for you to raise your right hand for me and stay steady for me, okay? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. What would you like to tell the court, Mr. McCord?
I'd like to tell the court that she didn't assault me. Whatever Mark they kept on saying was self-inflicted. I don't think this was a simple battery case because I was not assaulted at all by Mirage.
Okay, and let's see.
Your Honor, can I say something as well?
I don't know who's speaking, but no, not right this moment, as I am in the middle of speaking with someone else. But if whoever's speaking, if you come on camera for me, I'm happy to hear from you in your turn. Mr. McCord, are you and Ms. Duncan still together?
Yes, yes, sir.
Okay, you would still like to have contact with her?
Yes, sir.
And has this ever happened before?
No, sir.
And you're not afraid of her?
No, sir.
Anything else that you want to tell the court?
No.
Okay,
I
all
don't think
right.
no.
All right, now who was the other person that wanted my attention? Okay, you're on mute, ma'am, so hold on a minute. So
Hi.
first of all, wait, let me ask you the questions. Okay, can you, if you raise your right hand for me, do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, place your hand down, and what's your name?
Sherry Tucker. I'm her mom. She resides with me at 1270 West Peachtree Street.
Okay.
Josiah doesn't live there with us. It's her and me and my boyfriend that lives there.
Okay.
Yeah, and then I heard something about a Massachusetts charge. It's not possible. She's never been in Massachusetts.
Okay, all right. Well, we thank you for being here this afternoon, ma'am. Anything
Thank you,
further?
Your Honor.
What's the total of her bond?
Okay, we haven't gotten that far yet, Mr. McCord, so hang on for me, okay?
And
Okay.
Your Honor, I hate to interrupt. Based on that information that was just given by her mother, we are agreeable to lifting the portion of our recommendation that involved the stay away.
Okay. Mr. Cook.
Your Honor, given the various comments, we would be looking for signature bond. We would object to the FVIP. Certainly, they've lifted the recommendation for stay away, and beyond that, they would then be allowed presumably to have contact. So that would be our position.
Okay, for the battery, it will be a $2,000 signature bond through pretrial level 1. For the giving false information, a $500 signature bond through pretrial level 1 makes for a total of a $2,500 signature bond through pretrial level 1. No further violent contact with Mr. McCord and no drugs, alcohol, weapons while out on bond. All right.
Judge.
Good luck to you all.
This is per judge.
I got it, per judge.
We go to position number 40, Miss Venable, Nicole Venable.
Good afternoon, Judge Corey Bowles from Ms. Venable.
Yes, good afternoon, Mr. Bowles. Let's see. Good afternoon, Ms. Venable. You've been charged in case 24 CR 002802E with battery. Is there a history, Mr. Howard?
No.
Okay. Ms. Makaki?
Thank you, Your Honor. Officers were dispatched because a fight had occurred at 129 Mildred Street Southwest in Atlanta on April 29th, 2024. Upon arrival, a resident aide led the officer to the room of the victim, Miss Charamaya Marcelli, who had large gashes on the side of her head and who was also bleeding. She stated that the defendant came into her room and began attacking her, at which point the victim, Miss Marcelli, grabbed her handheld taser to defend herself and struck the victim in the neck. The defendant did admit to striking the victim multiple times, and the defendant stated that she did so because the victim told her, "I got something for you, B." Both parties did request an ambulance, and both were taken to Emory and Grady respectively. The state is recommending a $3,000 surety bond, stay away from the incident location, no further contact with the victim, and no drugs, weapons, or alcohol while out on bond.
If Ms. Marcelli is on the line and wishes to address the court, now is your opportunity to do so. Yes, Mr. Bowles.
Yes, Judge. Before you is Miss Nicole Venable. She's 20 years of age, Judge. She is a college student at Clark Atlanta University, which is where this incident happened. She is a political science major, for some reason hoping to be an attorney. We are asking for a signature bond, Judge. She has no history whatsoever. She has ties to the community, Judge. She has a cousin, two cousins, Stevie and Earl, who live here, and also an aunt who is an attorney, Miss Christina Essex. She's in healthcare. Your Honor, and I think it, just to be clear, it was my client. Well, actually, this is Miss Neal's client, but I'm subbing in for her today. It was her that was actually struck with the taser, which is why she had to be taken to the hospital, Judge. So, and she actually did turn herself in, Judge, when she was notified that she had a warrant. She turned herself in last night. So we believe she is a perfect candidate for a signature bond, Judge. She's taking finals this week over at Clark Atlanta University. So we want to get her back to that so she can finish up this year. But we are asking for a signature bond.
And this Mildred Street address, is that a dorm?
It's a dorm, Judge, but she does not stay in the same dorm with this other female. They both are college Clark Atlanta students, but she does not stay in the same dorm, does not have any of the same classes with this other female.
Okay, and so the Mildred Street dorm, the Mildred Street address, 129 Mildred Street, is that where her dorm is? Or I don't want to restrict her from going to her own dorm, but I need to make sure that I know that if the 129 Mildred Street is her dorm or not.
So it looks like the victim, Miss Marcelli, her dorm is room 204. So at the very least, a stay away from room 204 at 129 Mildred Street.
Okay, Mr. Bowles?
Yes, I don't believe she even stays in that dorm. And Ms. Venable, if you could nod, you don't stay in that dorm, do you? Okay, she doesn't stay in.
Okay, all right, okay. So it's going to be a $2,000 signature bond through the jail. No further contact with Mr. Marsali. Stay away from room 204, the 129 Mildred Street address, and no drugs, alcohol, weapons while out on bond.
Okay,
Okay.
Judge. Thank you very
All
much.
right. Good luck to you, Ms. Venable.
Next,
Good afternoon, Mr. Bowles.
All right, Judge. Have a good one.
Thank you.
we go to position number 39. Ms.
39.
Yes. Ugano.
Yes, good afternoon, Mr. Ugana, excuse me. You've been charged in case 24 CR 002798C with battery. Is there a history?
12 total on probation, possession of a controlled substance in a drug-free commercial zone. Got an open case for drugs. What else we got? Possession of cocaine with intent, tampering with evidence, possession of a firearm by a convicted felon, possession of marijuana with intent, 2019 FTA. He just got a history of drugs.
Okay.
Yeah, that's right.
Yes, Ms.
Yes, Your
McCarthy.
Honor. The defendant is accused of punching the victim, Taryn Skane, in the face with a closed fist, which caused swelling to her cheeks as well as gave her a black eye. This incident occurred on May 5th, 2024, and the location was 7684 Overlook Bend in Fairborn. The state is recommending a $3,000 surety bond. Stay away from the incident location, that's 7684 Overlook Bend. No further contact with the victim, Ms. Taryn Skane, and no drugs, weapons, or alcohol while out on bond. At this time, I would like to sound for the defendant, Ms. Skane, if she is on the Zoom.
Skane is present and wishes to address the court. Now is your opportunity to do so. Ms. Kim?
Yes, Your Honor, my client is 36 years old, and Your Honor, he's been here in Georgia for a long, long time, and he's actually living with his girlfriend at this 7684 Overlook. The complaining witness is actually a friend of girlfriend and who does not reside at that location. And that is, according to my client, it's his auntie's place where he resides with them. So stay away is objected, Your Honor. No further contact. He has no objection. We would like to request for a signature on bond through pretrial, whichever level Your Honor deemed to be appropriate, because he never had any violent arrest before. Everything else was non-violence. This is the first time that he's ever getting into this kind of trouble, and we would like to request for a signature on bond through a pretrial and no further contact. However, no stay away from the incident location. Thanks.
I have something to say.
Okay, Ms. Sims, is that your name?
Yes.
Okay, can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Yes, Ms. Sims.
So 7684, that is my address. He lives with me. I am his girlfriend. They are no longer here. So he can come back to the house where he lives. I have no issues with that. The whole incident yesterday was a complete misunderstanding. Her wife actually hit him on the head with a pole, so he just reacted. But other than that,
Okay, well, thank you for being here, Ms. Sims. Let's see, it's gonna be a $3,000 signature bond through pretrial level 2, 1-day anger awareness, no further contact with the alleged victim, no drugs, alcohol, weapons while out on bond. Good luck to you all.
I have another question.
Yes, ma'am.
So he has a signature bond because I just paid a bond.
Okay, well, he has a signature bond. That's what the court has
Okay.
ruled. All right,
Thank you.
you're welcome. Who do we have next?
Position 28.
You say 28?
A number may be different, Judge Morrow.
Yeah, I do
It's
think
Pike.
that.
It's
Okay,
Rebecca Pike.
okay, that's position 29 on our calendar, Johnson. Okay. All right, Ms. Pike, good afternoon. You have been charged in case 24 CR 002801C with criminal trespass and damage to property and willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
9th arrest, 2017 stalking, 2015 DUI, 2009 harassing phone calls conviction.
Okay, Mr. Graham?
Thank you, Your Honor. This incident took place May 4th, 2024. Law enforcement responded to a dispute at 1074 Peachtree Walk Northeast. It's apartment B501. Gustavo Alvarez advised that his roommate, Rebecca Pike, was intoxicated and damaged his bedroom door by striking it with an unknown object. Mr. Alvarez showed a video of Ms. Pike in the living room yelling, using profane language, making incoherent statements. Ms. Pike was in her bedroom at the time. She refused to come out, stating that she did not know why the police were there. Continued making incoherent statements, making references to mac and cheese, and that she did not eat the milk. Mr. Alvarez advised that her aggressive behavior made him fear for her safety, wanted to press charges. Ms. Pike resisted arrest by tensing both arms and moving her right arm forward when attempting to be handcuffed. She was taken to the ground and eventually handcuffed. We spoke with Mr. Alvarez, Your Honor. He is the owner of the incident location. He rented out one of the bedrooms to Ms. Pike, and she moved in just about 3 weeks ago. She passed a background check, but he didn't know she may have an alcohol problem. There have been multiple incidents of her being intoxicated, knocking on other neighbors' doors. This was the first time he had called the police. He confirmed the events in the warrant. And when the police were taking her away, she threatened him by saying, "Next time I see you, you and your dog better die," and some more expletives. The victims, Mr. Alvarez stated that he is afraid of Ms. Pike, wants a no contact to stay away, restitution for damages to the apartment, and he's okay with her having a one-time police escort. Your Honor, based on the nature of the incident, the state is requesting a $1,500 surety bond. It's $1,000 on the criminal damage and $500 on the willful obstruction. We're requesting an ADET, Your Honor, no further contact with Gustavo Alvarez. Stay away from the incident location, no alcohol, drugs, or weapons. And I do believe Mr. Alvarez is on the line if we can sound for him at this time, Your Honor.
Mr. Alvarez, if you would like to address the court, I need for you to raise your right hand for me. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I swear.
Okay, you can place your hand down. What would you like to tell the court, sir?
Just add what he just said, that while she was leaving the property, she did say, quote unquote, next time you see me, you better die, you little gay as fuck. You little gay as fuck, you and your dog. And I provided video evidence of that. She continually make homophobic slurs as I am a gay man, also mentioned my country of origin as I'm an immigrant originally from Spain. So there's been a lot of hate speech on top of this. And I only know her for 3 weeks. I feel very unsafe in my own house, and she threatened my life and hurting me and my dog. And I have multiple complaints from neighbors as well. So I don't want her to be near me ever again. Thank you.
Thank you. Thank you for being here, Mr. Alvarez. Mr. Dodas?
Yes, Your Honor. Ms. Pike is 35 years old, and she is a lifelong resident of the state of Georgia, as well as the city of Atlanta. As we heard from pretrial, there's no history of FTAs or probation violations. And it looks like her last cycle was in 2017. Ms. Pike did have another address, which she confirmed to me, which she can go to instead of the incident location, which she understands that. Ms. Pike is also a graduate of the Art Institute of Atlanta, where she majored in fashion design, and she currently works with America's Mart in sales, where she actually has a upcoming convention that she's helping run next week. Your Honor, we would ask for a signature bond with a one-time sheriff's escort to ensure that there's no further issues between Ms. Pike and the alleged victim, where she can get her property and get on with her life at a different address. She's fine with no further contact with the alleged victim. She just wants a clean, they both, I think, need a clean break. Your Honor, we are just asking for a signature bond at this time, given her lack of recent history and stable job.
Okay, for the criminal trespass, it'll be a $2,000 signature bond through pretrial level 1. The obstruction, $1,000 signature bond through pretrial level 1. Makes for a total of a $3,000 signature bond through pretrial level 1. 1-day anger awareness. No further contact with Mr. Alvarez. Stay away from the Peachtree Walk address. She can go back to that address on one occasion with law enforcement to retrieve her belongings. No drugs, alcohol, weapons while out on bond. Good luck to you all.
Next, we go to position number 27.
Okay.
That's what I'm
Okay. Where is 27?
Right
Is
here.
that courtroom 2?
Yes.
Okay. Yes, good afternoon, Mr. Najee. You've been charged in case 24 CR 002800H with battery. Is there a history, Mr. Howard?
I don't have anything for him. I'll defer to the state.
Okay, Mr. Graham?
Yes, Your Honor. So I'm showing a total of 39 arrest cycles. The most recent 2021 a probation violation conviction 2019 probation violation, 2019 theft by taking, 2019 shoplifting, no low plea, 2018 criminal trespass and willful obstruction, 2017 criminal trespass, 2017 shoplifting, and that's as far back as I went, Your Honor.
Okay.
And this incident took place on May 5th, 2024. Osman and G caused physical harm to Jason Velasquez by placing his arm around his neck, punching him in the face, causing red marks to appear. Our office has not been in contact with Mr. Velasquez. The state is requesting Your Honor signature bond through pretrial services. No further contact with Jason Velasquez. Stay away from the incident location, which is 3012 MLK Junior Drive, Atlanta. No alcohol, drugs, or weapons. And of course, we'd sound for Mr. Velasquez in accordance with Washington's law.
Mr. Velasquez is on the line and wishes to address the court. Now is your opportunity to do so. It's a tie.
Yes, Your Honor. My client is 45 years old. He is the father of one minor child. He is gainfully employed, working part-time in a warehouse job, and he's done that for over 4 years. He does deny the allegations as stated in the warrant, and he states that the complaining witness was the first aggressor. I know that the state has asked for a signature bond through pretrial services. I would ask for a signature bond through the jail, Your Honor. He has been suffering for the last year with a colostomy bag, and he's just been approved for surgery to have that removed and go back to his life as normal. It would be difficult for him at this time to report to pretrial, certainly to stay in the jail any longer than he needs to do. So I would ask for a signature bond through the jail. So hopefully by the time this comes up for trial, he'll be ready to appear in court, but we didn't have to report to pretrial once a month.
I do good, Your Honor. I've been doing real good.
Yes.
Real good.
Okay. All right, Mrs. G, it'll be a $2,000 signature bond through the jail. No further contact with Mr. Velasquez. Stay away from the incident location, and no drugs, alcohol, or weapons while out on bond.
Yes, sir. I got good. Thank you so much, bro.
Good luck to you, sir.
Yes, sir. Thank you.
You're welcome.
Thank you.
Next. In the back.
Position 44, Judge Wilson.
Your Honor, this is also a conflict case that we don't have a conflict attorney, Your Honor.
Okay, yes, good afternoon. Good afternoon, Ms. Wilson. Let's see, you have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. Unfortunately, this afternoon, we do not have a conflict attorney available for you. You can either proceed pro se if you choose without the advice of counsel, or I can put you on hold until tomorrow where we can get you an attorney. What would you like to do this afternoon?
24.
Okay. Ms. Wilson, you've been charged in case 24 CR 002782J with battery family violence. I believe I've already heard this case, Ms. Falk.
Yes, Your Honor, and the state's recommendation for Ms. Wilson is the same as for Mr. Banks. Your Honor gave Mr. Banks a $3,000 bond, pretrial services level 1 day anger awareness, no further contact, and we are not asking for a stay away for Miss Enna Juan Wilson. We're also asking for no alcohol, drugs, or weapons.
I made notes while I was doing Mr. Banks's case. Mr. Banks had 2 cases. So it will be a $1,500 signature bond through pretrial level 1. No further contact with Mr. Banks, and no drugs, alcohol, or weapons while out on bond. Ms. Wilson, I'm going to let you out on a signature bond, but you're going to have to make sure to show back up at your next court appearance, okay? All right, good luck to you, ma'am.
And Your Honor, we are asking for 1 day anger awareness, which Your Honor gave to Mr. Banks as well.
And for some reason, I made a note not to give her the anger awareness. It must have been something that I heard in his case, so I won't be requiring that of Ms. Wilson.
Okay.
Thank you, Ms. Wilson.
Next, we do position number 11, Mario Johnson.
Your Honor, this one is going to require a clear courtroom and a
Okay.
suspension of the feed.
Can we take Mr. Dawson last, please?
Yeah. Smith. Next, we can go to position number 36, Raekwon Smith.
You don't want your all time. What you go away from?
Good afternoon, Mr. Smith. You've been charged in case 24 CR 002794A with battery. Is there a history, Mr. Howard?
Smith, yeah. 2022 simple battery, 2019 probation, 2018 ag assault, 2016 robbery, simple assault conviction. He's wanted out of the cab and he got no bond and felony earlier. So that's
Yes, Ms. McConkey.
Yes, I thought I saw this morning that he had some open warrants for aggravated assaults in 2023.
he got no bond for it today.
Okay, thank you. So the officer responded to 2583 Rockwell Street Southwest in Atlanta on March 3rd, 2023. The victim is a Mr. Ricardo Buchanan, who stated that he had gotten into a verbal dispute with the defendant regarding him leaving his 5-year-old daughter unattended in the living room. When Mr. Buchanan, the victim, entered the bathroom, the defendant started banging on the door, stating that he also needed to use the bathroom. When the victim exited the bathroom, the defendant began shouting at him and punched him above his right eye, with a closed fist, which caused the victim's face to swell. The defendant then left in an unknown vehicle and stated to the victim, "I'll be back for you." We did get an opportunity to speak with the victim, who said he only knew the defendant for a short time and they were roommates. The victim confirmed the events that were stated in the report. He also stated that there had been no further incidents with the defendant, and he is not interested in pressing charges or being involved in the case. We are recommending a $5,000 surety bond, stay away from the incident location. Given his history, no further contact with the victim, even though the victim did state that, he's not interested in pressing charges, we do have some safety concerns. No drug, weapons, or alcohol. 1-day anger management as well. And I believe this is a Riverside issue, so I'm actually going to ask for a signature bond through the jail.
Okay. Any objection, any of that, Mr. Dotis?
No objection to a signature bond through the jail, Your Honor.
Okay, $5,000 signature bond through the jail. Stay away from, no further contact with Mr. Buchanan. Stay away from the Rockwell Street address, and no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Smith.
Yeah, you come up and sit down. Next, we can go to position. Not you. We can go to position number 15. Mr. Goodwin.
Yes, good afternoon, Mr. Godwin. You've been charged in case 24 CR 0028108 with criminal trespass. Is there a history, Mr. Howard?
This is Godwin.
Yes.
What was the last bond? I had to step away.
5,000 through the jail.
Thank you.
All right, Godwin. Second arrest, has current felony charges Got a possession of a Schedule 2 open out of DeKalb County. Let me check on those felony charges though.
Okay. Yes, Ms. Pataki.
Thank you, Your Honor. Officers were dispatched to a domestic dispute at 5870 Millwick Drive in Johns Creek. The victim of the battery is James Godwin. He is the defendant's father. Mr. Godwin stated that the defendant had a mental breakdown, became belligerent, and became so frustrated that he attempted to punch his father with a closed fist. Mr. Godwin blocked the punch with his right arm, which resulted in a raised red mark on his forearm. The defendant is also accused of throwing Virginia Godwin's folder against the dining room floor, which caused it to break. And for that, he was charged with criminal trespass. We did get a chance to speak to the defendant's father, Mr. James Godwin, who stated that the defendant does live at the incident location. This is an ongoing issue. The defendant, according to Mr. Godwin, uses drugs regularly and gets violent when he does not get his way. Mr. Godwin has stated that the defendant has been violent with him in the past and has also punched holes in the wall. Mr. Godwin further stated that if the defendant returns, he's sure that this will happen again. And at this time, he doesn't want any contact with the defendant and also wants the defendant to stay away from the residence. The state is recommending a $2,000 surety bond for the battery, a $1,000 surety bond for the criminal trespass, so a $3,000 total surety bond. Stay away from the incident location. No further contact with the victims, Virginia Godwin and James Godwin. No drugs, weapons, or alcohol. 1-day anger management, and also alcohol and drug evaluation and treatment. At this time, I would like to sound for either of the victims, either Mr. James Godwin or Virginia Godwin, if they are on Zoom.
So Ms. Godwin on the line. Now's your opportunity to address the court. We only have a accusation for criminal trespass. I don't have a battery on my calendar.
No.
I believe both were called down, but let me check.
Judge, I do see the battery charge. I can pull it into the case, but we don't have the acquisition for it. But we just need the acquisition.
Okay, so you all will need to file the accusation for the battery charge.
Absolutely.
I'm working on it right now, Your Honor.
Okay, thank you, Ms. Falk. Yes, Ms. Kim.
Yes, Your Honor, my client, Mr. Godwin, is 27 years old, and indeed he is 110 credit. He has been getting 110 credits from Georgia State University. He's planning to go to law school soon. He is also working as a recording engineer. Your Honor, my client strongly prefers to have no further violent contact with his parents that he resides together at 5870 Millwood Drive. I called her mother. I saw his mother on the Zoom hearing in the beginning of this hearing, but I guess after 3.5 hours, maybe she kind of left. But I believe that she wanted to have a contact with her son. We would like to request for a signature on bond through pretrial, whichever level you seem to be appropriate, because he has 4 felony charges. He has a bigger fishes to fry. So these 2 charges, we would like to get signature on bond through pretrial. Thank you.
For the criminal trespass, it'll be $1,000 signature bond through pretrial level 1. For the battery, a $4,000 signature bond through pretrial level 1 makes for a total of a $5,000 signature bond through pretrial level 1. No further contact with his parents. The Godwins stay away from their home incident location, the home address. He can go back to that address on one occasion with law enforcement to retrieve any belongings. No drugs, alcohol, weapons while out on bond.
Thank
Good
you.
luck to you, sir.
This per judge.
Can you repeat the bottom out?
A total of a $5,000 signature bond through pretrial per judge. Okay. Who do we have next?
Your Honor, we have Dawson here, but there's a few announcements on the calendar.
Okay.
Position number one, they have the sin bond. Position number 14 got a consent bond.
Okay.
Position 20 was accepted to have.
Okay.
Position number 24 consent bond.
Okay.
Position 41 and 42 waived their appearance.
Okay.
Position 1 on the add-on calendar was waived also. And you can go to position number.
What about position 5?
What's the name on position 5?
Morel Beavers.
That's Pad.
No, actually, it's not. The state
Not.
would not decline to null pros the case, given how many criminal trespasses he's had recently, including his last one, which was less than a month ago, and PAD would not accept him unless we dismiss the case, which we declined to do.
Okay. Okay.
So are we here seeing him today?
Yes, Your Honor.
So are you gonna be able to bring Mr. Beavers to us? Courtroom 2?
It's probably not there.
Who's the person seated?
I think this is.
That's
and did you hear
Mario
my,
Dawson.
did you hear my question about Mr. Beavers, courtroom 2?
Yes, are we able to bring?
Okay, all right, so we'll go ahead and do Mr. Dawson, and then while we're waiting for Mr. Beavers, we'll go ahead, we'll do the waivers, and then we'll do Mr. Beavers last. Mr. Dawson, let's see, good afternoon. You've been charged in case 24 CR 002808D with 1 misdemeanor offense and the offense of possession and use of drug-related objects. Is there a history, Mr. Howard?
Your Honor, I'm just, have we ceased the public feed on this?
Recording, Your Honor.
Recording.
Okay.
It's okay, but YouTube, we usually stop